Kamberi Mabota, Director of the UNEP Law Division, and finally from our dear colleague, Professor Nicholas Robinson from Pace Law School, Chair Emeritus of the IUCN World Commission on Environmental Law and Governor of the International Council on Environmental Law. So you'll hear brief remarks from each of them now. Jose?
Just 1 second, a minor correction. On behalf of UNEP, we will have the pleasure to hear from our colleague, Arnold Krajhoba.
Yes, apologies, Arnold. Thank you. Jose?
Jose Igreja's presentation is by a recorded video. Thank you, Juliana.
Good morning. I feel very honored to be present today with such a distinctive panel. September 2021, Rome. Elected President of the International Association of Judges, EAJ, the new Presidential Committee defined under my coordination 3 priorities to our mandate. Besides our core mission, a vigorous defense of rule of law and judicial independence, a new main concern was recognized. With the humble responsibility of representing judges' associations or similar bodies from 94 countries, undoubtedly the world's largest judges' organization, confronted with a background where globalization of the law stresses the need of a more engaged and active participation of the judiciary on the international arena, knowing the vital moment societies faces today combating for democracy against populism and autocracies in defense of human rights, including the right to a sustainable planet, EAJ immediately identified environment as a decisive topic for us, the judges. There is no planet B was the alluring expression used to enlighten the urgency of this focus and the weight of our strategic option. Since then, EAJ assumed a larger role in the discussion of conservation of nature areas. EAJ was actively present in the conference Stockholm +50 and under the leadership of the Global Judicial Institute on the Environment and its indomitable president, Minister Herman Benjamin, the judiciary gained importance, gained traction in the center stage of environmental policies. Confronted with a triple planetary crisis, it is fundamental to empower judiciary. The requirements for an independent and impartial application of water law are obligatory to guarantee a global conservation of nature, being as the judges often the last resort for the actualization of rights provided by law. As stated in Principle 10 of Brasília Declaration, judges should strive to achieve water justice due process by ensuring that persons and groups shall have effective access to judicial and administrative proceedings and to remedy and redress. The present event, proudly sponsored by EAJ, with judges but also scholars and diplomats from different juridical cultures and traditions, is yet another demonstration of our mutual commitment today in the context of water justice. Environmental law certainly exists to protect the planet, but more than that, its laws, strengthened by an invigorated jurisprudence, appear as a powerful resource to safeguard new generation fundamental rights. Therefore, it is indispensable to know them, to develop them, to enforce them. Let me then reaffirm an unequivocal and determined pledge of judges worldwide to the aims defined by the United Nations, in particular, in this case, CDJ 6, clean water and sanitation for all. At the present crossroads, we refuse to be silent in complicity or to wait for others to tackle crucial quandaries. To quote Samuel Beckett, we will try again, and fail again, fail better, and then tirelessly we will continue, no matter what. In fact, dear colleagues, there is no other option to ensure a common future for our communities and for our fellow citizens. Thank you very much.
Ministro Benjamin, I turn it back to you to introduce our next speaker, the ambassador.
Yeah, it's my great pleasure to introduce Ambassador Almeida Filho. He is a leading voice in our foreign service, a recognized and well-known diplomat, and at the moment representing Brazil at the United Nations. And for the past few days we have been trying to speak to each other, and he would leave the Security Council where he is representing Brazil and try to connect me, and this just showed his commitment to environmental law, and especially to this topic, which is water. As you know, this event is co-sponsored by the Brazilian Ministry of Foreign Affairs, and later on, at the end of this introduction, I will thank a few colleagues from Itamaraty. But at the moment, I would like just to highlight how important Ambassador Almeida Filho is for all of us, Brazil, and especially at the moment when he represents Brazil at the United Nations. So, Ambassador Almeida Filho.
Minister, thank you very much. And through you, I say good morning to our colleagues here. And I wish you all a very fruitful morning, afternoon, or evening of discussions. And I'm certain that it will be that way. If I may speak a little bit from the heart and deviate from my notes, it's a pleasure and an honor to be here. My personal career intertwines a lot with the SDGs. Since I had the Department of Energy in Brazil in 2017, all the way to my position now as Deputy Permanent Representative at the UN. And one conviction that I have is that the SDGs is not the work of a group of bureaucrats. It's not something that has to be on paper. If we are to achieve that very ambitious agenda, we have to work together. We have to work in as many sectors of society as are available to work with us. The SDG is fundamental as a program for the whole planet, and it cannot be restricted to just an expectation that it will be implemented by somebody. It has to be expected to be implemented by us all. And that sense of ownership of the Agenda 2030 is something that's fundamental for us to achieve the best results in 2030. And I do expect that later this year, during the summit of the SDGs, we can show good results, and we can show the degree of commitment that you are showing now to the SDGs. So in 2018, we had in Brazil a number of documents that that were issued at that moment, like the Parliamentarians' Manifesto, the Declaration of Prosecutors on the Right to Water, the Brazilian local and regional government call for action on water and sanitation, as well as the Ministerial Declaration. And one of them is a follow-up that we are going to discuss here today. The SDG that we are going to discuss, as you all know, is a very cross-cutting, cross-sectoral topic of the SDG number 6. Water is related to everything that we do. So is SDG 16 on peace, justice, and institutions. So linking this cross-cutting aims is very, very synergetic, I would say. And I expect really that we are able to come up with ideas, with reflections that will help us all to implement better and in a deeper way the 2030 agenda. So, Minister Benjamin, I thank you very much for that initiative. It's really seeing that the SDGs is something that belongs to us all, and that is part of our societies, and make myself even more proud of the Brazilian judiciary to see that we are involved in such a way with the Millennium, Sustainable Development Goals. I thank you very much, and I thank you all for your involvement. So we can proceed to the work of this morning. Thank you very much.
Professor Antolini.
Thank you, Ambassador, for your remarks. I think you have framed our discussion today in a beautiful framework of the SDGs. Let me introduce now Christina Voigt, Chair of the World Commission on Environmental Law. Professor Voigt.
Thank you so much, Professor Antolini, and a warm welcome on behalf of the IUCN World Commission on Environmental Law to all participants to today's webinar, and of course to all my distinguished fellow speakers here on this panel. It's a great honor and it's a great joy being here today on this webinar focusing on that important issue of water justice. I would like to thank all the partners involved in this, in the planning and execution of this webinar, in particular the Global Judicial Institute on the Environment, the UNEP Law Division, but also the Brazilian Ministry of Foreign Affairs, ISO, and the Brazilian Association of Judges. While the term climate justice is widely used these days, water justice is only just about now to gain international attention, and very rightly so, because water justice lies at the very heart of justice, because water lies at the heart, at the core of life. And water justice is a concept with many dimensions, which I'm sure we will discuss in this webinar today and will explore. First, it deals with fair and equitable access to freshwater resources for communities, for people, for individuals, but also for the natural world, for flora and fauna and all ecosystems that depend on water. And it's not just the quantity of water, it is also the quality of water. And second, there's a spatial dimension to water justice. It applies everywhere where access to water is under stress, and that can be within a city, that can be within a village, that can be within a state, within a region, or in a global context. Third, there's a temporal dimension of water justice. It does not just apply right now, but it also needs to take into account a transgenerational aspect and justice to future generations, which, as much as we do, will depend on access to water. And here we have a major threat, as we all know. Climate change will severely affect access to fresh water due to droughts, heat waves, melting of glacier, and salination of groundwater. And the more we do right now to address the threat of climate change, the more we do also for water justice. And that means that climate justice and water justice have to be seen in conjunction. They have to be addressed in an integrated manner, and only together can be solved. And here in this context, law plays a very important role in providing the legal ground for water justice. And we see this, for example, in the recognition of a human right to water, but also in the recognition of the United Nations General Assembly last year on a right to a clean, healthy, and sustainable environment. And we need national laws that are effectively implemented in conserving and protecting watersheds, conserving freshwater sources and groundwater aquifers. And here in this context, of course, also the judiciary plays a very important role in upholding these laws and interpreting them, enforcing them. And this is, of course, where the 2018 Brasília Declaration of Judges on Water Justice comes in, which, as we just heard from Ambassador Filho, is a very important document which has raised the issue of water justice globally to a global discourse. There are many principles in the declaration which I recommend everyone to read and study. But maybe in particular, one principle is one that I would like to highlight at the tail end of my brief talk here. And that's the principle in dubio pro aqua. When in doubt, and we are often in doubt due to scientific uncertainties or legal interpretations that are open, but when in doubt, laws have to be interpreted, have to be designed and interpreted in a way to best protect water and related ecosystems. And this principle, as I'm sure we will hear later today, is already being applied, and it's instrumental in legal decisions by courts in several jurisdictions, for example, the Supreme Court of Pakistan and of Argentina. And hopefully it will inspire policymakers and judges in the years to come. My hope is that these principles will also guide and inspire international cooperation on water justice. WCL stands ready to work together with partners worldwide on the development of legal frameworks to support and enhance water justice, and we're very much looking forward to cooperating on that very important topic. Thank you very much, and back to you, Professor Angelini.
Thank you, Christina, for your beautiful remarks. It's so wonderful to have WCEL present here in so many ways. Next, let me introduce again, my apologies, Arnold. Arnold, and I hope I have your title now right, your current title, Deputy Director of the UNEP Law Division, but soon to be the head of the European Office of UNEP in Geneva. Do I have that right?
Yes.
Wonderful. Thank you. Next to you, Arnold. Thank you for joining us.
Absolutely. Thank you very much, Denise, and welcome to all of you on behalf of UNEP to this event. It gives me a very big pleasure to deliver to you the opening remarks on behalf of the Director of the Law Division, Patricia Kamarian-Bote. Distinguished participants, ladies and gentlemen, today, millions of people live in critically water-stressed countries or with high water vulnerability. Droughts are increasing, such as the one in the Horn of Africa, as are floods like the one we have recently seen, for example, in Pakistan. People's livelihoods continue to be decimated as a result. And these problems don't stop conveniently at national borders. These problems are transboundary issues that need transboundary answers. We have just heard from Ambassador Phil Yu a very eloquent reference to SDG 6, SDG 16, and both of these underpin the fundamental role of strong institutions. Institutions that are or should be robust, democratic, effective, and accountable. And in this context, let me turn to our friends in the judiciary. Judges can create precedent and inspire action. Where domestic laws and policies are lacking, judges can fill gaps. Judges breathe life into the law by effectively implementing the laws on the books. They are often our last resort in ensuring the protection of our rights, such as the right to clean water. The right to water, as we know it, recognized in most national legal orders through constitutions or domestic laws, was very much the child of both the innovative and protective role of courts and judges. Last year, we saw a monumental advance on a human rights approach to environmental protection. As we know, in July of last year, we saw the recognition of the right to a clean, healthy, and sustainable environment as a human right by the UN General Assembly. Access to safe and sufficient water is directly linked to this right. Indeed, as the three planetary crises, climate change, biodiversity loss, pollution, affect the environment, they will necessarily threaten the right to water. Therefore, even if the legal framework to fighting water injustice and inequality seems to be set up, an integral part of implementing this framework is ensuring that courts and judges around the world are able to safeguard this right, both in its substantive and procedural elements. In truth, there is no one-size-fits-all model that we can automatically apply to the orders. But that's the beauty of the Brasília Declaration. It provides guiding principles that should be taken into account to ensure the enjoyment of the right to water, including in its procedural elements, but it also adapts to national contexts. This event will therefore be unique in having a very broad range of speakers from all around the world explaining their experiences in ensuring the right to water in the courtroom. It will be good to draw conclusions and maybe identify good practices and challenges. Some of it will be global and some regional, some will be national. But today, we know that a judge deciding a water case should not only look at economic or land perspectives, but especially look at the interplay with human rights and other social, ecological, and ethical implications. As this human right approach to environment will gather more and more support, as well as hopefully be broadly implemented, we will need judges to be familiar with environment-related concepts and principles in their interaction with human rights. This will allow and improve knowledge-based decisions, especially considering the technicality of some of the issues involved, like how the water hydrological cycles interplay with climate change, different water management models. I could go on. You can count on UNEP to support you in this mission. We are proud of our partnership with the Global Judicial Institute on the Environment to build judicial capacity around the world. We are proud of our role in implementing the Montevideo Environmental Law Program to support the progressive development of environmental rule of law. We are proud to be associated with this event. I wish everyone a very fruitful discussion during today's event. Thank you very much.
Thank you, Arnold, for your remarks and bringing all of the UNEP partnership and support all throughout this entire process. And we also want to just now thank your team for supporting the logistics of this global webinar today. Before I introduce Professor Robinson, I just want to remind everyone that the event is being recorded for posterity and for all of the partners, and also being broadcast now on YouTube. So with that, let me introduce our dear friend and colleague, Professor Nicholas Robinson. Take it away, Nick.
Well, thank you very much, Professor Antolini, and distinguished fellow members of this opening panel, colleagues from around the world. It's a great pleasure for me to be with you personally, as well as representing the International Council of Environmental Law. I am reminded that SDG 6, which is tremendously important, as Ambassador Almeida Filos described, really is the latest of a number of statements about the human right to water. Water is not just what we are. We humans are largely made up of water. The people around us, the plants, the animals are all part of water. The biosphere, as we see it from the space station, is a blue orb, mostly water. Water is so essential to the existence we have on this planet that it's wonderful that it is now moved into the framework of a judicial paradigm in which the right to water is a judicially recognized right. Dubio pro aqua, as Professor Voigt has indicated, really is a norm that transcends the norms of justice. It goes right to the heart of life itself, to human beings. So I think this panel today, this program today, is terribly important in advance of the United Nations Conference on Water next week. The UN Environment Program issued a terribly important scientific synthesis report entitled Making Peace with Nature. It documents quite well the triple crisis that we have today of climate change, biodiversity loss, and the chemical pollution which is growing around the world. And what is common to all those three crises? Well, there are many common elements, but first among them is water. We are in the middle of this crisis, this environmental crisis, a global crisis, largely because of our mismanagement of the environment. And water, since it's part of us and is right in our face all the time, we have to deal with water. But water reminds us of this triple environmental crisis. It also reminds us of the joy we have in water. Water is not just a problem. As I said, it's part of us. And there's a great love for water around the world, and that can bond us together in many ways. The UN meeting next week has a number of interactive dialogues which will discuss water, and the International Council of Environmental Law will be attending. I don't think the importance of water justice is well enough reflected in those dialogues, to be quite honest. I think we need to start introducing the water justice dialogue into all of the many fora around the world which deal with both environment and human development, sustainable development. But I think, therefore, that the discussions we have here and all of us participating from around the world can feel empowered to take up the water justice theme and to present it in different forums around the world. With those brief opening remarks, I want to congratulate all those who have helped create the concept of water justice. It's a tremendous step forward, and I look forward to the debates today and our discussions. Thank you very much. It's a pleasure and honor to be with you. Over to you, Professor Antolini.
Thank you, Professor Robinson, for framing our discussion today in those historical and global contexts. Great appreciation. Antonio?
Well, thank you so much, Professor Antolini. Before we move to the next stage in the program, as I mentioned in my opening statement, this event would not be possible without the contribution of the Brazilian Ministry of Foreign Affairs. And I would like to mention a few people that were critical in making sure that the Global Judicial Institute on the Environment, the World Commission on Environmental Law, UNEP, ICEL, and the other partners would have this discussion that is about to begin in terms of substance. Well, first of all, Ambassador André Correia do Lago, the new chief Brazilian negotiator for the environment, a well-known diplomat in Brazil and internationally. Presently, our ambassador in India, before in Japan and Moscow, and to the benefit of the planet, he will be leading the negotiations in the next 4 years. Ambassador Figueiredo, also a good friend he has been the Minister of Foreign Affairs before the US, the ambassador of Brazil in the United States and in many other countries. And now he is coming back to Brazil to be the ambassador for climate change. And this shows the importance that our Ministry of Foreign Affairs and Brazil is dedicating to this fundamental problem of our times. Minister Maria Angélica Ikeda, the new head of the Environment Department, she's also somebody that has a very long history associated with the protection of the environment in general and environmental law in particular. So we are in very, very good hands. And finally, Secretary Victor Bahia, based here in Brazil at the moment, that helped us with the logistics and in connection with the outstanding team of Brazilian diplomats at the United Nations. And again, many thanks to Ambassador Almeida Filho. Please convey to your colleagues our warm gratitude for their help. Well, we move to the next phase. We are going to have an introduction to the program by Professor Denise Antolini. I would like just to mention that Professor Denise Antolini is someone that is absolutely well known in the environmental law family, but she's not well known, she's admired. And I would say, Denise, I hope you don't mind, she is adored by the students and by her colleagues. And she together with Professor Nick Briner, were at the forefront of this debates that we had that led to the Brazilian Declaration. I could say much more, Denise, but we are short of time, and I know you would criticize me if I would take even a few seconds from our program. Denise.
Thank you, Ministro Benjamin. I appreciate your keeping that short, and all the feelings are mutual. I just want to take a few minutes here during this introduction to frame, again, kind of reframe where we are today. So we are very privileged to be actually the very first side event in the program for the UN Water Conference, the United Nations 2023 Water Conference. And so it is very exciting to be with all of you to kick off what is essentially an entire week of a focus on global water issues, and to start it off with such a distinguished group of academics, judges, diplomats, and institutional partners is really amazing. I think Antonio mentioned this before, but there were many, many hundreds, I think, if not thousands of side event applications, and we're very fortunate that this one was selected, particularly with the help of the Brazilian government and our partners. So here we are kicking off this amazing UN conference. Along with my colleague, Professor Nicholas Briner, we will be framing the program today and also talking about outcomes later on. And I want to say it's always a privilege to work with Nick. We have both been great fans, supporters, and partners with the Global Judicial Institute for many years, supporting its work, including today. And I wanted to mention that this is actually the second time that the Global Judicial Institute on the Environment has had a side event at a UN conference. And the first one was just in June of 2022, where GJIE and many partners was at Stockholm +50. And that was the first kind of foray into the UN official programming, and this is the second. So you can see the trend, and I expect GJIE and partners to continue to participate at this global level. let me just say that that is really remarkable to have high court judges, justices from around the world participating directly in these conversations. So you will hear more about that throughout the program. I also want to say a little bit about the design of today's program. It really provides an incredible mosaic. Each of the speakers, as you've seen already, has only a few minutes to share with us their perspective. And by doing that, by giving everybody a spotlight or a highlight opportunity, you're going to be able to hear from many more voices from all around the world. So I consider it to be a beautiful judicial, academic, and diplomatic mosaic of water justice based upon the extraordinary declaration. As Antonio mentioned, we had the privilege of being in Brasília for the 8th World Water Forum in March of 2018. And when I looked at the date again this morning, I realized it's almost exactly 5 years that we had the process, the conference on judges and prosecutors on water justice. And for those of us who were there, it was such an extraordinary experience. I think it lasted 5 days. It involved, so many people. And by my notes, 140 judges, prosecutors, diplomats, scientists, professors, and other leaders participated in the events that were organized. And the Brasília Declaration was one of actually 8 different signature products that came out of that extraordinary experience in Brasília. So with that, let me just end by adding a little Hawaii touch to my introduction before we get to the first panel. And you will hear also from another speaker from Hawaii in just a few minutes. But I wanted to say that water in Hawaii, like in so many places, is essential to our being. And I think everybody has touched on this in various ways. And I wanted to tell you the word for water in Hawaiian, the Hawaiian language is vai, W-A-I. W-A-I is water. And the word for law in Hawaii is kanawai, K-A-N-A-W-A-I. So the word water is embedded in the word law in Hawaii. It is so essential to how the world works, how the society works, that in the Hawaiian culture, water is absolutely central, not just to living, but to the legal system. So again, it's a great privilege to introduce where we're going next. So next we will have the first high-level panel focused on the drafting process of the 2018 Brasília Declaration of Judges on Water Justice. And let me emphasize the of judges, and you will hear that reference and its importance in the speakers to come, the extraordinary convening of judges to create this document. So this morning we have on the first panel co-chairing Justice of the Supreme Court of Costa Rica, Damaris Vargas Vasquez, and also Justice Maria Filomena Singh from the Supreme Court of the Philippines, co-chairing the panel. And then as speakers, Ministro Benjamin, Nicholas Breiner, Arnold Kralhuber, Scott Fulton, who is the President Emeritus of the Environmental Law Institute. Good morning, Scott. And from the University of Hawaii, Rhiannon Terarii Chandler Iau, who is a post-JD research fellow and teaching fellow at the Kuhuliau Center for Excellence in Native Hawaiian Law at my law school, the William S. Richardson School of Law. So with that, I will turn it over to Justice Damaris and Justice Maria to take over co-chairing this panel. Thank you.
And if I may, just a reminder, we have interpretation in Spanish and French, and a contribution of the World Commission on Environmental Law. Many thanks, Professor Christina Voigt, and the Deputy Chair, my dear friend and colleague, Eman Shekawe.
Muy buenos días, Denise. Gracias por la oportunidad de participar en este evento tan importante con expertos tan reconocidos a nivel internacional. Este es un momento de importancia crítica para analizar el estado de derecho ambiental y el papel de los tribunales de justicia del agua, precisamente. Ya hace algunos años que estuvimos en Brasilia y que firmamos este importante documento, la Declaración de Brasilia de Jueces sobre Justicia del Agua del 2018. Lo hemos integrado en nuestras resoluciones desde ese momento, con una clarísima responsabilidad para la Suprema Corte de Justicia. Estar en este evento es una grandísima oportunidad. El agua es parte de los desafíos globales establecidos en la Agenda 2030 de Desarrollo Sostenible. Lo hemos asumido con responsabilidad porque es parte también del pacto de cumplimiento que firmamos en nuestro país, tanto sector privado como sector público y los tres poderes del Estado. De manera tal que participar en este evento, los tribunales de justicia, es una gran oportunidad para nosotros y para los demás países del mundo, hacernos saber de el rol que jugamos los jueces y las juezas en garantizar la implementación de este derecho, como bien nos señalan los representantes de la UICN que nos han antecedido. Al resolver conflictos judiciales vinculados con el agua, debemos ser innovadores y aplicar los principios ambientales, en especial el indubio pro natura, pero sobre todo el que sea un derecho progresivo, nunca regresivo, y para eso estamos nosotros en la judicatura, para defender este derecho. En Costa Rica se introdujo el derecho al agua con prioridad para la población de manera reciente, garantizando así la prioridad más allá del uso industrial y de otros usos que pudiera dárseles. Para el sector justicia, el derecho al agua es una prioridad. De manera comprometida y visionaria firmamos esa declaración, de forma tal que ya la hemos incorporado en nuestras resoluciones. Es un poco difícil poder hacer realidad este derecho que fue establecido en el 2010, el derecho al agua y al saneamiento, por la Asamblea General de Naciones Unidas, estableciéndose así que debe serlo en cantidad suficiente para uso doméstico y personal, segura, aceptable y asequible, cuyo costo no supere el 3% de los ingresos del hogar, además de ser accesible físicamente con una distancia a la fuente que no supere los 1000 metros y su recogida no debe superar los 30 minutos. Realmente este es un gran desafío. En algunos países es más fácil poder garantizarlos, en otros es bastante difícil. Para mi país no es complejo el tema, pero siempre tenemos que estar a la vanguardia de proteger los derechos de todas las personas, muy especialmente de las poblaciones en situación de vulnerabilidad o vulnerabilizadas, entre ellas la población indígena, que está ubicada en lugares más distantes, y siempre hay barreras para que puedan disfrutar de este derecho, de forma tal que no invierto más tiempo para escuchar a los expertos que nos acompañan en esta actividad tan importante. Muchas gracias, Denise. Y un saludo muy especial para todos y todas desde Costa Rica.
Thank you, Justice Tamaras. May I turn it over in the interest of time to Justice Maria Filomena Singh from the Philippines. Thank you for joining us.
Thank you, Professor Antolini, and good evening from the Philippines. This is particularly momentous for our country in particular, because right now, pending in the Supreme Court of the Philippines are several big water rights litigations, and we stand on the very brink of formulating very much needed policy in relation to water rights. And so this is really a privilege for us, and it will provide us guidance. So in the interest of time, because we want to hear from our speakers who have very valuable information and experiences to share with us, perhaps we can proceed already to our first speaker. Justice Benjamin, of course, we all know, is the president of the GJIE. Justice Benjamin, over to you.
Well, thank you so much. Good evening to my colleague Maria Filomena. Early good morning to my colleague Damaris Vargas. It's a great pleasure, as I have already said, to participate in this event. My role here, and I will compress my presentation so the other speakers who could have more time, is just to give you the background information about how the declaration came up. In 2017, the two senior diplomats in charge of the organization of the 8th World Water Forum, both dear friends, Ambassador José Marcondes de Carvalho and Ambassador Reinaldo Salgado Almeida, came to my chambers and told me about the World Water Forum and asked whether I could help in organizing something different. And I said, well, something different could be for the first time to have the judges participating in this event. But this is not something that I can organize alone. We need to put together a team. And this team, several of them are here today, others are not, others have retired from Supreme Courts around the world. So we began the preparation of the two-day event in combination with a moot court, not competition, but event, Professor Antolini's idea. And I asked Professor Nicholas Breiner to help us together with Professor Antolini in the organization of this event. During the organization, I thought it would be necessary to have a declaration, a document, a final document, but not any type of declaration. We have so many declarations, but one that we would prepare and have several meetings before that by Zoom, and then try to have principles that would resonate with judges around the world. And in that effort, I had my dear colleagues, Nicholas Robinson, Arnold Craig Huber, Christina Voigt, and several others helping in the preparation of this document. The challenge were, first, that the declaration had to reflect both common law and civil law perspectives. Second, the declaration should not be long, and we ended up, it was a suggestion I made, compressing, I think we had like 30 or 40 principles, but so we can call it the 10 principle declaration with a very rich preamble. Third, that because the declaration is a document that comes from judges, it should reflect the way we judge express ourselves. We express ourselves based on precedents, but also we innovate, but we innovate within the international law framework, the constitutional framework of our countries, and the strong traditions, as Professor Robinson mentioned, that each country has in respect to water. Some of our colleagues thought that that would be an impossible task. Frankly, I thought that too, but we decided to try. And to our surprise, we not only succeeded, but now this declaration has been cited in a number of cases decided by Supreme Courts around the world. Of course, in a dialogue with national clauses in the Constitution or in legislation. So I use this opportunity to thank all of you for doing what you did, our partners, and we had the same, it's usually the same suspects, the usual suspects, right? It's the World Commission on Environmental Law, UNEP, ICEL, at that moment, the Global Judicial Institute on the Environment, which was still, was just 2 years old, the Asian Development Bank, and several other organizations. You can go to the web, Google, and you are going to see even the proceedings, the dialogues. Let me just stress one principle that my dear friend and colleague Christina Voigt alluded to, and others in their opening statements: the indubio pro aqua principle. I thought that because we now, there are so many cases that mention the indubio pro natura principle in Costa Rica, Brazil, and several other countries, Argentina, and so on, Asia and Africa, and Europe. I thought that it would be good to sophisticate that principle and have a principle indubio pro water. Well, then I called a professor of Latin at the Federal University of Rio Grande do Sul, and I said, can we say that in Latin? How would you correctly say this in Latin? And he said, it's very easy. It's indubio pro aqua. So it sounds ancient, but this is probably the youngest environmental law concept that we have, but it resonates. If we use Latin, it resonates with other legal principles that we have, not in just in environmental law, but in criminal law and in other areas of law. So I stop here. Many thanks to the two co-chairs. I did save a few minutes for the next speakers.
Thank you very much, Justice Benjamin. I remember when you messaged me and told me that the UN officially approved this side event, and we were so excited, precisely because of what you mentioned, that all over the world, wherever you are, if you're a judge, when you read the Brasília Declaration, you feel connected to everybody else doing the same type of work all over the world. So thank you again very much. Now let's proceed to our next speaker, Professor Nicholas Briner, of course, is from the School of Law of the Louisiana State University, and he is our side event academic co-coordinator, Professor Nicholas Briner.
Thank you very much, Justice Singh, for the introduction. And thank you to Justice Benjamin for setting the stage on this panel, and for Justice Damaris Vargas Vasquez as well for those comments. It is such a remarkable privilege to be here, to be able to join with all of you around the world. This is really, truly a global meeting. It's remarkable to be able to participate live with so many of you around the world, and such distinguished friends and colleagues and justices who are doing remarkable work related to the conservation of water that is so essential for maintaining not only human life, but all other life on our planet. As Justice Benjamin has said, this is really a remarkable document, this declaration. And in 5 years since it was drafted, it has been cited by judges in numerous court opinions. And I think that's because of the simplicity of the concepts here that are so readily translatable to so many different legal systems and disputes and potential cases that might involve water. And I want to refer to a couple of the principles here, especially for anyone watching who has not yet had a chance to look at this declaration. It came together through consultation with judges from over 50 countries that were present in Brasilia for the World Water Forum. And special thanks to all those who participated in drafting it. And the focus in creating this declaration is to list principles that can guide decision-making. And the idea of having a principle is, of course, that it can be applied in a lot of different contexts. It's not a bright line rule that will tell you exactly what needs to be done or what cannot be done, but it provides the guideline in order to help make decisions and understand what are the various interests involved in water law. Principle 2 of the Declaration refers to water justice, land use, and the ecological function of property, that I think so clearly and well lays out the interconnectedness of water with all other environmental and human rights issues that we face in our world. And the principle is that any person who has a right or interest in the use of water resources or land has a duty to maintain the ecological functions and integrity of water resources and related ecosystems. There's a recognition in this principle that all human activity is going to be interconnected with water quality, and water quality and water resources and land are all essential and interconnected in supporting and sustaining human life and all other life on Earth. And to be able to have the right to use water to support our own life also carries with it a duty that we maintain the ecological functions and integrity of that water so that it can continue to be beneficial to all other life around us. A recognition that things carry on after our own lives, and that all of the actions that we do are interconnected with everything in the ecosystems around us. There's a recognition in this principle of all of the interconnected crises that we face, the major environmental challenges of climate change, biodiversity loss, and water scarcity are all obviously related to water and water quality and the way in which water is managed. And so that principle carries with it a great guide for how we as humans ought to understand our relationship with the resources that we use in order to support our own activities. That as we do that, we ought to maintain the quality and integrity of those resources for the use of all others who might come after us. Together with that principle is interconnected so many concepts of law, of legal responsibility, of liability, of duties, of the responsibilities of property owners that can be applied in any different kind of legal system, regardless of how that legal system organizes concepts of property or ownership. Several speakers, Professor Voigt and Justice Benjamin and others have already mentioned in dubio pro aqua. And as Justice Damaris Vargas mentioned in opening this panel, all of these principles together carry with them a progressive nature. The concept of non-regression is not explicitly mentioned as one of these principles because it's already becoming recognized as a principle of environmental law in connection with human rights law and the idea that rights must move forward, that once a right to water has been guaranteed, we cannot allow short-term political interests or other pressures to push back against or lead to a regression or backsliding in the protection and guarantee of those rights. And that same concept permeates this entire document as well, that each of these principles carries forward toward a greater recognition, a progressive recognition of the right to water, the human right to water, as well as the rights of nature as well that are entirely consistent with this document, that can be recognized and can be guaranteed and implemented and fulfilled through our legal systems. So it's a remarkable document. And again, in just 5 years, I think it is taking shape as more of all of you are looking at it and reading it and recognizing the ways in which it can be adapted to each legal system and jurisdiction. Water is the driving force of all nature, and regardless of what we might do, we cannot outsmart water. Water will certainly push back harder than we can push on it. But it's with great gratitude I get to speak with all of you today and encourage you to consider these principles as all of you have been discussing and doing such great work up until now. I'll echo the ambassador's comments from earlier, Ambassador Almeida, who said that, you know, this is not the work of just one group of individuals or one group of bureaucrats, but that rather we can all work together, that the guaranteeing the right to water is fundamental for the entire planet. And so this fits in so well with all of the work that is part of the realization of sustainable development goals. Thank you very much, and I look forward to hearing from the rest of you.
Thank you, Professor Briner, and especially for emphasizing the interconnectedness, not only of the challenges, but also of the legal principles that are available to all of us in addressing the particular issues in relation to water rights. And there's no better weapon for all of us than the declaration with the 10 guiding principles. And so now we proceed to our next speaker, and he has already been introduced earlier, presently the Deputy Director of UNEP Law Division, Mr. Arnold Kreuber.
Thank you very much, Justice Singh, and also Justice Vargas Vasquez. It's a great pleasure to be able to address you again and speak a little bit about the small role that I've been able to play in supporting the drafting committee for the 2018 Brasília Declaration of Judges on water justice, and share a few, if you so will, personal reflections with you on the declaration. You've already heard the drafting process for the declaration was really a very participatory, very open process that started long before the 8th World Water Forum, through webinars, through meetings, hosted primarily by the judiciary in Brazil under the leadership of Justice Benjamin. And it allowed judges to also engage with other stakeholders. We've already heard that judges engaged with prosecutors, but also other experts. And so it really allowed judges to come together around this declaration and formulate their voice with regards to water justice. But looking back now, 5 years on, it's remarkable how fast time flows, that we're already celebrating 5 years of the Brasília Declaration. But looking back now and with the benefit of hindsight, I think it's remarkable that these 10 principles in the declaration, which were set up with the aim to guide judicial decision-making on water, how much these 10 principles have helped not only to highlight the importance of the role that the judiciary plays in adjudicating water-related cases, but also in terms of providing much needed guidance and impetus to judges and judicial administrations worldwide in treating such cases effectively, holistically, and also in building the required capacity among judges. So that was a key part in drafting this declaration, that judges wanted to also give their voice to continued education of the judiciary around the world. And again, this is the judge's voice, and that was driven, primarily, of course, through the Global Judicial Institute on the Environment. But from UNEP's point of view, that is a very important part of the Brasília Declaration, that it speaks to this continuous capacity building of judges to better equip them to deal with environmental cases around the world. Again, looking back now, I firmly believe that it is also no coincidence that the 2018 Brasília Declaration is the first specific pronunciation by judges on environmental rule of law related to a specific environmental medium or resource. I don't think that's an accident, right? When environmental rule of law first, began to play its role as a paradigm shift in the field of environmental law, coming out again of discussions that were heavily influenced by the voice of judges surrounding the Rio +20 conference, when the term was for the first time intergovernmentally recognized in 2013 by UNEP's governing body, and then followed on by the 2016 Declaration on Environmental Rule of Law. The Brasília Declaration takes environmental rule of law and speaks to it with regards to a specific environmental resource. And just like the air we breathe, water is just such an emblematic resource that does not only show us how the triple planetary crisis affects the livelihoods and the environment at large, but water also provides us with a gauge and an indicator of the much needed changes that are required to effectively address the triple planetary crisis. And perhaps also it provides us with an indicator how well we are doing in addressing these crises. If the water resources around the world are not healthy, then probably we have other environmental issues also to take care of with great urgency. So I think, again, it's no mistake that the Brasília Declaration is the first pronunciation by judges on environmental rule of law with regards to a specific environmental medium. The declaration is a very powerful statement, of course, as we've heard, by judges, for judges, but it also speaks to parliaments and governments, which are, of course, in the primary driving seat to enact the legislation that hopefully will change the lives of millions of people around the world who live in water-stressed countries or countries with high water vulnerability. The declaration also reflects the commitment of the judiciary to ensure increasingly that their functions in safeguarding and administering justice in matters related to water resource are carried out with great respect for environmental stewardship, prevention, precaution, and good governance. I want to repeat also the references that have already been made to the SDGs, because again, I believe the Brasília Declaration is a very clear, I have not seen a clearer pronunciation with regards to the SDGs coming from the judiciary, that they also have a role to play in realizing the SDGs of a whole of society, or in the course of a whole of society approach to make sure that the SDGs become a reality by 2030. I have helped lead UNEP's work on what we termed as the greening of water law, an effort to highlight the need to pay greater attention to the environment, water laws and regulations. And it is a milestone, I believe, attributable also to the Brasília Declaration, that judges are now increasingly moving away from general criteria such as administrative, civil, and criminal law, and understand that water resources are an integral and intergenerational collective good. I think that really should be celebrated. While the right to water itself preceded, of course, the Universal Declaration that we saw last year of the human right to a clean, healthy, and sustainable environment, by 12 years. It was adopted in 2010, but the 10 principles enshrined in the Brasília Declaration express not only the importance of making access to safe drinking water and sanitation services a reality, but also the importance of water as to ensure fundamental rights, including human rights. And therefore, this declaration is an important vehicle towards achieving also this new universal right to a healthy, clean, and sustainable environment. Judges have in the Brasília Declaration acknowledged very clearly that actions whose potential impacts on the resource, its services or ecosystems that are unreasonable, disproportionate or excessive in relation to their benefits should not be acceptable. This acknowledgement has resonated in judiciaries around the world. And in the 5 years since the adoption of the declaration, we see a corresponding trend in judicial decisions that recognize the interdependence between water and other elements of the natural environment, including important ecosystem connections. This, again, I think gives us another reason to celebrate the achievements of the Brasília Declaration, looking back now 5 years ago. But to conclude my brief reflections, I think it's fair to say that much more still needs to be done. And of course, the work cannot stop here. But the foresight of the judges who drafted and adopted the Brasília Declaration on Water Justice 5 years ago continues to provide an effective tool, inspiration, guidance, and pathway for judges as they continue towards working for water justice for all. Thank you very much, and I'll close my brief reflections here and would like to hand it back over to our two wonderful co-chairs. Thank you.
Thank you very much, Director Kramer. And certainly that resonated with us judges, those of us on the bench, when you said that the declaration really is the voice of the judges speaking out towards this very, very important issue. And I think also we should start thinking about other ways that judges can push this agenda forward, not just through our decisions, but through our other interconnected activities with the members of the legislature, as you pointed out, and with also the members of the executive departments in our countries. Thank you very much again. Now we proceed to the next speaker, who is the President Emeritus of the Environmental Law Institute. We call on Professor Scott Fulton.
Greetings, everyone. Distinguished judges and colleagues, as always, it's a privilege to be with you. As it was to be a part of the gathering in Brasília that we're recalling today. Water is life. The law is the means by which we protect this living resource, and the courts are our means of breathing life into the law through their judgments. And keeping with this idea, around 25 years ago, the United Nations Environment Program that Arnold is representing today had a visionary notion that judges around the world, charged as they are to uphold the law and deliver justice, could contribute greatly to a sustainable future, particularly when they are equipped with an understanding of the importance and nature of environmental challenges and are exposed to how other judges around the world are reckoning with such challenges. This idea led to the development of UNEP's Global Judges Program, which set out to conduct regional judicial symposia on environmental law around the world and convene the 2002 Global Judges Symposium on Sustainable Development and the Role of Law in Johannesburg, South Africa, an historic, first of its kind gathering of more than 120 chief justices and judges from over 60 countries around the shared concern of environmental protection. I was a judge myself at the time and participated in that gathering on behalf of the United States and had the privilege of staying with this effort in the years since. I think it's fair to say that all of the judges assembled back then in Johannesburg were very much taken by UNEP's theory of change, and this powerfully contagious idea, coupled with the innovation of leaders in the international judicial community, would ultimately lead to the birthing of the Global Judicial Institute on the Environment, which has become a shining light for the important work of the courts in advancing environmental rule of law and producing the future that we want and need. And this light was never on brighter display than in Brasília in 2018, when judges came together to take up this vitally important topic of water justice. That meeting, of course, birthed the visionary declaration that is at the center of today's reflection. In a moment, we're going to be hearing from judges about how this instrument is informing judicial thought and decisions. In this panel, we're talking principally about how the declaration came to be, which is important because these kinds of declarations do not simply materialize out of thin air. Rather, there is important work that is needed to lay a foundation for such a statement. And that work has several ingredients. I'll talk about a few. First, it's helpful to provide participants with read-ahead scholarship that touches on key themes so that participants come to the meeting tuned in to the suite of issues that will be discussed and that might be taken up in a declaration or an outcome document. Second, the draft declaration that is to be introduced must be prepared carefully to lean forward while remaining sensitive to the needs and interests of those whose concurrence is desired. In the case of the Brasília conference, the read-ahead materials took the form of a compendium of judicially authored articles that we published in the Environmental Law Reporter that provided regional experience and perspectives on water justice from Africa to the European Union to Latin America to the United States, with a cover article by Justice Benjamin and myself that provided synthesis and attempted to connect the dots. As participants in this event today, you've been provided those materials. I do hope that you will read them once more as they strongly make the case for the principles that you find in the declaration and offer some early examples of the application of those principles. In Brasília, as we've discussed, great care was taken in the formulation of the draft declaration. Judges tend to be fiercely independent and self-assured. So getting close to the mark with the draft was very important. The involvement of judges in the drafting process was key as these judges could then go on to serve as explainers and champions for the document. As it happens, judges listen best to other judges. Questions were raised, discussions occurred, adjustments were made, the draft getting its job done well, and the Brasília Declaration was thus born. In closing, for my part, an accomplishment like this requires at least one further ingredient, and that is a leader who can call an assemblage of this kind together, shepherd them through a process that leaves them alert to the urgency at hand, and who can speak with both authority and empathy to those gathered. And that leadership was provided powerfully in this case by Justice Antonio Benjamin, without whom this important declaration simply would not have happened. And the same can be said of the many other courageous judicial leaders who helped birth this important declaration and who are now breathing life into it through their decisions. A special shout out to Justice Michael Wilson from Hawaii, always a great contributor to GJIE's work, for the Hawaii Supreme Court's unanimous decision just a few days ago in the Helco Power case, recognizing that the right to a life-sustaining climate system is grounded in the state's constitutional environmental quality guarantee, with Justice Wilson's concurring opinion also finding such a right embedded in the right to life within the state's constitutional due process clause and as guaranteed by the constitutional promise of preservation of the public trust. All relevant here because impacts to freshwater systems are among the gravest of our climate concerns. So I'll close there. Many thanks again to the judges for their remarkable vision and leadership as reflected in this declaration. And thanks to you all for your attention.
Thank you very much, Professor Fulton, for that insight into the drafting process of the Brasília Declaration. certainly the three elements that you mentioned, the read ahead scholarship, and then the careful drafting, and of course the leadership. These are things we can easily relate to as we went through all the materials that were sent to us ahead of time for this particular event. Thank you again, Professor Fulton. And now we go to the last speaker in this panel, and she is the Executive Director and a teaching fellow at the Kahuli Ayo Center for Excellence in Native Hawaiian Law of the William S. Richardson School of Law, Rhiannon Terari Chandler Iao. Rhiannon?
Mahalo. Aloha and good morning. My name is Tereri Chandler Iao, and it is an honor to be here with you today on this high-level panel discussion with such esteemed members of the global environmental justice community. I would like to express my deep appreciation to all who contributed to the Brasília Declaration of Judges on water justice. This document offers the world a valuable roadmap to achieving Sustainable Development Goal number 6 and ensuring access to water and sanitation for all. Weaving together environmental truths and proactive public policy, the Brasília Declaration affirms principles enshrined in international environmental law treaties. In principle number 1, as was just mentioned, the declaration importantly recognizes water as a public interest resource where the state exercises stewardship of the resource for the benefit of both nature and people, including present and future generations. Hawaii's experience with water justice embodies the language of the Brasília Declaration, especially with regard to public interest and public trust resources. Our tiny islands are a microcosm of the world, suffering many of the same threats and challenges that our global community seeks to address. Like an island, our planet's resources are fragile and finite. For nearly 200 years after Western contact with Hawaii, our native systems of natural resource management were in decline, along with the populations they supported. During this period, natural resources were managed by the government not for sustainability, but for immediate economic profit. Hundreds of streams in Hawaii were diverted away from native communities where they once supported traditional food systems and ecosystem health. For a time, it seemed our environmental challenges were insurmountable until we finally found hope in strengthening the environmental rule of law. Through the brilliance of key community leaders, Hawaii held a constitutional convention after statehood, which led to the incorporation of protections for public trust resources in our state constitution, as was just recently mentioned. This activated a valuable legal handle for communities and, importantly, for judges who were able to utilize this to restore justice. In the year 2000, the Waiahole court case represented the tensions over conflicting uses of water for economic development and for the perpetuation of cultural practices and natural ecosystems. Decided by the Hawaii Supreme Court, this case gave life to the public trust principles newly enshrined in the state's constitution. It exemplified the power of the judiciary to protect and defend the public's rights and interests in the waters that sustain the ecosystems and people of Hawaii. I'm proud to say that my former professor, Denise Antolini, was instrumental in the Waiahole case. Mahalo for your work. This tremendous victory on behalf of the environment was made possible by the willingness of judges to do what is right and their bravery to stand up for our finite natural resources in the face of political and economic opposition. From our experience in Hawaii, we can see how the Brasília Declaration exemplifies and amplifies this type of courage with the integrity that is needed to protect resources and people around the world. I'm grateful to each judge and justice that has made this honorable commitment. The Waiahole case in Hawaii laid a firm foundation for other cases since then, which have cited to it in protection of public trust resources and the communities they support. The work I do at the William S. Richardson School of Law at the University of Hawaii, Manoa, continues to build on the work of Waiahole case to expand water justice in Hawaii for all people. I currently co-teach the Native Hawaiian Rights Clinic at our law school, where we are assisting families that are seeking to utilize stream water for traditional and customary Native Hawaiian rights and practices. This includes water for traditional forms of agriculture, as well as religious and cultural uses. Without access to water, Native Hawaiians and other indigenous peoples would be unable to continue many of the cultural practices that shape our identity. The Brasília Declaration recognizes this in principle number 3, noting that indigenous peoples' rights and relationships with traditional and customary water resources and related ecosystems should be respected. The declaration goes further, suggesting that free, prior, and informed consent should be required for any activities on or affecting water resources or related ecosystems. I pray this will be implemented in Hawaii and around the world, and I encourage justices to cite to this declaration often in defense of this principle. The declaration affirmatively acknowledges the importance of indigenous knowledge and cultures in their contribution to water sustainability. In this way, the Brasília Declaration, with its important principles, represents more than water justice. It represents a roadmap for the survival of cultures and people. The carefully crafted words and principles of the Declaration offer powerful language that may be readily taken up by any state and embedded into their laws for the protection of water resources. Moreover, while constitutional provisions and statutes of various states may protect water resources, it is the judges who give life to these and other provisions. I thank you deeply for your service, leadership, and courage to say what is true and right, even when it is not economically or politically favorable. These are the types of judges that our planet and our peoples need the most. The declaration illustrates the transformative power of environmental laws and judges and empowers the work of people like me and so many others around the world. I cannot thank the authors of the declaration enough for their work in crafting a water future for us all. Thank you for allowing me to join you in this discussion of your important contributions to our global community. I wish you all the best in the road ahead. Mahalo.
Justice Singh, I think we have an audio issue. Your microphone is off.
Oh, I'm sorry. Thank you, Justice Benjamin. Thank you, Terari. That was very, very inspiring. I don't think us, the members of the bench, the members of the academe, everyone in this, joining us in this cause needs more inspiration, that to hear from the younger generation, the validation that we need, that the work we are doing is really impacting their lives. So thank you, Terari. And I think that the power of the declaration really is not in the words that it contains, but in the actions that we do based on the words. So with that, I turn over the session to Professor Antolini. Thank you very much.
Thank you very much. Let's have a global round of applause for our first panel. It was excellent. Thank you to our co-chairs, to our marvelous speakers. I think everybody who's watching is enjoying what is essentially a global buffet of voices on this important declaration, and weaving together perspectives will continue now with our second high-level panel. So we have a slight change. Instead of Justice Sapanamala from Nepal, who had some connectivity issues, I think Justice Nambita Dambuza, who has stepped in both as a speaker and as a chair of the session. We are so delighted to have her. You will hear from her first as a chair, and then you will be, I think, very delighted, we all are, to welcome 1, 2, 3, 4, 5, 6, 7 High Court justices from around the world, including Justice Nambita. I will let her do the introduction since she is chair of the panel, and I will turn it over to our dear friend, Justice Nambita Dambuza.
Thank you, Denise. I hope I'm audible. And good afternoon, good morning, good night to everybody. I am also delighted, and it is my honor and privilege to be part of this gathering this afternoon. I join the previous speakers in highlighting the value of this declaration in providing the principles also serve as guidelines to us judges. I have no doubt that in future years, the value of this declaration will be widely acknowledged. Our speakers in this session are the following. The first is Justice Ricardo Lorenzetti. He is the Justice of the Supreme Court of Argentina, and he's also a member of the GJIE board. He will be followed by Justice Syed Mansoor Ali Shah, a Justice of the Supreme Court of Pakistan, also a member of the GJIE board, and I will follow Justice Mansoor. There, Justice Alfredo Gutierrez from the Supreme Court of Mexico, also a member of our board, and then Justice Fabian Reynard, Justice of the Conseil d'Etat of France, and member of GJI board. Thereafter, we shall have Justice Joe Williamson. He is the Justice of the Supreme Court of New Zealand. And last will be Lord Justice Keith Lindblom, Justice of the Court of Appeal of England and Wales, and a member of the GJIE board. We will then go straight to Justice Lorenzetti to give us his.
Can you hear me?
Yes, you are quite audible.
Okay, thank you. Thank you very much, Nambita. It's a great pleasure for me and an honor to participate in this panel and this high-level international seminar. Thank you to all the organizations that are co-organizing this meeting, that give us an opportunity to share values, and also to remember those exciting moments 5 years ago in Brazilian conference, in the drafting process of the Declaration of Water Justice under the leadership of Justin Benjamin. Well, I think the Brazilian Declaration of Judges on water justice is very, very important. And our court, my court in Argentina, adopted in 4 cases those principles. Just because of our limited amount of time, I refer only the principles that we are adopted, not developing the cases because we don't have time. First of all, our court recognizes the human right to drinking water. The court established that access to drinking water directly affects people's lives and health. It is important to say that when we speak about the human right to drinking water, we are talking about quantity, but also quality that Christina said before. And not only for humans, it is important also. And the other question is that judges should protect the right to human water, to access to water within the scope of collective rights. This is also important because it is essential to protect water, but maintaining the nature function as a system and its capacity for regeneration and resilience. This is important because when we speak about the access to drink water, fresh water, there is a problem with the abuse of rights. And the question is how to maintain the resilience of the system. We need to bring a balance in our cases. This is, I think, very important. The second question is the ecocentric or systemic approach. The legal paradigm which manages the regulation of water is ecocentric or systemic. And it does not only take into account private or state interests, but the system interest. This is a very important assumption of our court. The court underlined the importance to see the conflict from an integrated perspective. It explained that the resolution of the case required the adoption of measures aimed at the river basin in general and not restricted to territorial jurisdictions, since environmental conflicts are not limited from political or jurisdictional divisions. The court underlined that the very concept of river basin is one of unity, in which the water cycle is understood as a whole, connected to a specific territory and environment. The third question or principle we are assuming in our court is a polycentric perspective in the legal process. The characterization of the environment as a collective good or public good, as the declaration express, that belongs to the community of common use and indivisible. This is a concept that we shared with Antonio Benjamin a long time ago. Collective goods belongs to the community and it's of common use and indivisible. This approach is very, very important because the classification of the case demands a consideration of interest that exceed the bilateral conflict. And we have to approach or to have a polycentric perspective, since the rights affected are several. For that reason, the resolution in the case shall not be limited to solve the past, but essentially to promote a solution focused on future sustainability, which demands a decision that foresees the consequences derived from it. So, two comments here. The first one is the polycentric perspective, because we have to see different interests in the case. It's not only bilateral. And the second is to focus not only on the past, this is traditional in the courts, but in water cases and also in environmental cases, you have to pay attention to the future. For the principle in dubio pro aqua, we have a case, Mahul case in 2019. Here the court said, especially the principle in dubio pro aqua, consistent with the principle in dubio pro natura, which in case of uncertainty is a principle of interpretation. That said, in case of uncertainty, established that environmental water disputes must be resolved in the courts and the applicable law interpreted in the most favorable way for the protection and preservation of water resources and related ecosystem. We quote it here, the Brasília Declaration in our sentence. We have another, I don't have any more time, but the preservation of glacier, we have another case, barrick exploration. In this case, we repeated some of the principles of the Brazilian Declaration. So, in order to be limited in the time, I would like to say that the issue of water is gaining global significance in such a ways, no longer a matter of fact. Here it's important to say from the legal point of view, the legal theory, that we can find the word water in a lot of texts during the history. But the question is, the word water was because there was another right to protect. For example, in private law, we can read a lot of text in status in different countries, but water is referring when a private law have to define property. And in the public law, for example, in urban law, we can find water, but the question is protect human health. The big change nowadays is that water is creating law nowadays. It's not just a passive fact. It is a subsystem that generates its own regulations and categories. This is a big change in the area of legal theory. Nowadays, we have water law in different contexts, in all the countries and in different questions. But the question nowadays is to protect the system, the basin, or the system of the water. Consequently, it's not longer admissible to have a law that allows everybody to use water in any quantity and for any purpose. It's no longer possible for water to be a mere de facto assumption of subjective rights, but rather this must adapt to the function of the subsystem, recognizing its circular and systemic nature. It's time that we think of water problem in terms of scarcity and competing interests that must be fairly reconciled. This is important because the qualification in the declaration of the Brazilian Declaration that water is a collective good is situated in the social sphere and also entails a replacement of an anthropocentric ownership model to a different approach. So the environmental rule of law must reflect this approach, and this is the framework we adopted in the Argentina Supreme Court. This is briefly the cases and the principles we adopted in our court. Thank you very much.
Thank you very much, Justice Lorenzetti, for that provoking presentation, and in particular, highlighting the polycentric nature of the decisions that we make in our courts every day and the potential abuse thereof. Our next speaker will be Justice Mansour Ali Shah.
Thank you, my friend Amita. Good evening from Pakistan. It's such a pleasure to be in this delightful company of friends who think of the nature, who think of the environment, and whose hearts are beating in the right direction. It's always a pleasure to be in this company. I love this ecosystem of my friends, and I wish this continues for a long time. You see, Leonardo da Vinci once said that water is the driving force of all nature. But let me tell you that it could be a driving force of devastation also. Coming from Pakistan, which has been seriously hit by floods last year, where 1/3 of the country was under floods, and as I speak, 4 million children are still near contaminated and stagnant water. So in this, as Denise put it, in this global mosaic, I might bring a color of, quite a hurtful picture of how things are. And let me assure you that being a citizen of Pakistan and being a judge of the Supreme Court in Pakistan, we got oversensitized to the issue of water rights and water justice. And water justice now means a totally new thing for us because of the recent devastation and what water rights are for us now. So just want to share some of the perspectives that our court has taken post the Water Justice Declaration of Judges in 2018. A wonderful, absolutely wonderful document that gave us that platform to build jurisprudence on. So as a judge, I wish to sort of share some of the dimensions and interventions that we've done post 2018 in developing the declaration a bit further. So let me just underline once again that water is deeply connected with human life. There is no question about it. And I would like to, I think nobody else has said it better than the British-American poet H.W. Auden, who said, "Thousands have lived without love, but no one without water." So that kind of explains the relationship between human life and water. But more importantly, water has a very deep connection with the planet. The water cycle is constantly cycling through the Earth's atmosphere, oceans, and the land, and helps regulate distribution of water around the planet. So it's an important core of the way of human life, of the living organisms on life. So having said that, just want to highlight the declaration, which means a lot to us in Pakistan in particular. The declaration recognizes 10 principles, of course, but they're very strong principles, like involves environmental stewardship. It talks about intergenerational equity. It talks about sustainable ecological systems, customary rights, the prevention and precautionary principles, the in dubio pro aqua principle, the internalization of external environmental costs, including polluter pays and the user pays principle, the good governance, holistic approach involving integration of environmental factors, and a very important concept of procedural water justice, which means a lot in our context now. So having said this, we started off by considering water as a human right, for sure. Our Article 9 of the Constitution talks about right to life, and we said that right to life includes right to access to clean water. This was the first dimension or the intervention that the Supreme Court did, and the Supreme Court recognized that a right to pure and unpolluted water, and right to safe and healthy environment was part and parcel of right to life. So this is the starting point of our intervention, but I need to move forward as to what has been the recent developments after this. Water justice takes a new form when climate change enters the equation. The earlier right to life and right to water and right to access to clean water was within the framework of the environmental justice, but climate change changes things, you see, and especially coming from a country which suffers at the hand of climate change. We do not contribute to the greenhouse gases. So our entire planning is adaptation. So you need to understand that coming from a country which has an adaptive approach towards climate change, how does water justice work out for us, you see? So climate change, of course, has significant impact on water resources. It alters the precipitation patterns, which has been a clear example of our recent floods last year, where the monsoon rains, the precipitation went up by 75% and leading to those huge floods that we witnessed last year. So it increases water scarcity, increases droughts, the water quality is affected as it alters water chemistry, the melting of the glaciers, the rising of the sea levels. So climate change has devastating effects on water, and as a consequence on water justice. So now, coming from a country which has to adapt to this change in the climate, our approach, judicial approach, has also to be adaptive. So our water justice approach is also adaptive in nature. It is far bigger and far more complicated and complex compared to perhaps other countries who have mitigation as their issue, dealing with climate change. So we have to deal with a lot more to deal with water justice. For example, adaptive approach looks into a number of areas like health security, food security, energy security, the human displacement, human trafficking, disaster management. All these aspects are now related to water justice for us. It's a big scope, because at everything, you see, if you look at it deeply, water is behind all these things. So water justice, if put in the right place, would be an approach to deal with this, with these devastations that are taking place. And the adaptation plan, or a judicial adaptation plan on water justice, will have to deal with all these sectors. It's a very broad canvas for countries which have an adaptation plan to address climate change. The second intervention which climate change and adaptation has taught us over the years is that we need to move away from the anthropogenic approach. We need to move away from thinking that water is access to water, access to clean water for humans. We need to get the humans out of the equation and need to move on to a more biocentric approach in understanding the whole story of climate change and the whole story of water justice. It's not about humans alone. We need to start thinking about the other living organisms on this planet. We need to start thinking that nature has rights, and we need to transcend beyond human rights to natural rights, or rights of nature. Because if we were to start protecting the dignity of nature, the rights of nature, automatically we'll be protecting the dignity of humans and the human rights. So let's not put human rights at the center of this debate, but put nature at the center of this debate to understand the whole thing more holistically, because it's been too long that we've been talking about humans and human rights and access to clean water. We need to move beyond, because there's a lot more happening, which we witnessed in Pakistan in the recent floods. We are playing around with nature. So it's a high time that we start protecting nature and start respecting the dignity of nature. So that is one big intervention where our courts have recently recognized that we need to move this paradigm shift from anthropogenic to a more biocentric approach. So some of the recent cases are talking about adjudicating water and water-related cases, and to be mindful of the essential and inseparable connection of water with environment, land, and the other ecosystems. The whole intersection between nature, planet, other living organisms, and human beings needs to be brought into the picture. That's an important context that I wanted to highlight. Water justice has also been moved on to yet another category. In Pakistan, due to the recent floods, you must have heard of COP27. Now they've come up with loss and damage agreement for the first time. Our damage in Pakistan alone is about $30 billion, and the economic loss is another $35 billion for a thing that we've not done. I mean, Pakistan has not contributed to the greenhouse gases. We've been affected by the climate. That's been the way things are outside. So it's something that's beyond our control. So another dimension of water justice in a recent decision of the Supreme Court has been that we need to now, as a part of water justice, need to see whether these funds would ever trickle down to Pakistan. Will we be attending to these 4 million children who are still sitting by stagnant and contaminated water? We haven't really got rid of that water which is standing there, and the disease and the other problems that are following. So will that water, that money come through? Will that funding actually trickle down to Pakistan? And if it does, how will it be managed? Because our recent, the funds that were related to SDGs, we don't know how those funds got trickled down to the projects where they actually changed the life of people. So part of the water justice in a recent decision, the Supreme Court has held that it is within the ambit of water justice to ensure that the funding that comes in from loss and damage will also find its way to the right place, and will make sure that floods are not repeated next year, or if they were to be repeated, what kind of disaster management plan, what kind of adaptation plan Pakistan will be building. So water justice has moved on to look into areas of funding, on how the funding has to come into Pakistan. That also now falls within the ambit of water justice. So I just wanted to share some of the interventions, moving on from just pure right, human right, moving on to a natural right, and moving on to rights where we are looking at a whole set of areas to manage water justice. Water justice gets more complex than other countries. And also in the recent context of COP27, the loss and damage, how to handle the money that's going to come in, the funding that is coming, that forms part of water justice. So that's all I wanted to say. And these are the interventions. And I must once again underline that the declaration has been the most important watershed event in 2018, which has given us this, the power to move on and build on water justice the way we are building on it today. It's all because of this declaration. So salutes to all the people who were part and parcel of the declaration at that time. Thank you very much.
Thank you very much, Justice Mansour, for that hard-hitting presentation. And indeed, we have been thinking of you and your fellow citizens as we have been watching the devastation in your country. Thank you for reminding us we need to adapt our approaches to water justice, as you have set out. The next speaker is me on the program, and as it is reflected on the program, my name is Nambita. Oh, sorry, I didn't realize that I had put my camera off. My name is Nambita Dambuza. I am a judge of the Supreme Court of Appeal in South Africa. And again, it is my privilege to join this event today. I start my reflections highlighting that in the 2018 declaration, we acknowledge the trust that the public has in courts to be able to realize human rights in general, and their human right to water and sanitation in particular, and to prevent the need to preserve existing water reserves. We also affirm in the declaration the centrality of water law and the environmental rule of law for protection of water resources and ecosystems, and for promotion of water security. But sometimes it is difficult to determine where water security lies. I think it means exactly our duty in the positions in which we are placed for protection of water resources and to promote sustainability. It means that we must consider that water must be accessible, that water must be affordable, and that it must be of acceptable quality for consumption, particularly in water-scarce countries like mine is. Having made the undertakings that we have in the declaration as judges and colleagues, it is our responsibility, firstly, to approach our role as judges in a manner that affords citizens the necessary standing to approach the courts, to assert public interest to acceptable quality, affordable water. Standing is an important doorway for enforcement of rights, particularly for vulnerable communities. In sum, therefore, water security calls on us to consider availability, sustainability, accessibility, affordability, and acceptable quality of the water that our administrative structures provide. We then also take into account the relevant socio-economic conditions of those that are affected or of those that approach us in particular cases that serve before us, as well as the need of consideration, that is both the human needs reserves and the ecological needs reserves for future generations, as it has already been highlighted. These factors are central components of our decision-making process so that we may reach reasonable, just, and findings that promote sustainable water use and conservation, including protection of freshwater resources, and particularly protection of freshwater resources. We look to these components and we look for them as we consider the applicable domestic and international laws and regional and international agreements to which are acceded. We analyze how these instruments address these factors. Through analysis, we as judges contribute to the interpretation and explanation of the relevant environmental laws. We refine these laws to sounder and more useful comprehension, and we deepen environmental law. Effectively, we must be mindful, although we must be mindful of the principles of separation of powers, we must be alert to the duty of on us to contribute to lawmaking. We have been entrusted powers to fashion remedies to promote water security. And the declaration empowers us by providing these principles that guide us in performing our task. And these include principles of being cautious, of taking the necessary precautions, and when we are in doubt, to rule in favor of nature, and in this instance, for preservation and promotion of water security. As we adjudicate disputes, it is crucial that we remind ourselves repeatedly that courts are in a unique position to add momentum to realization of the Sustainable Development Goals in general, and in particular, the goal of ensuring water availability and accessibility and sustainable management of water. Indeed, as has already been said, there is no one size fits all, but there are commonalities. The declaration provides principles that advocate prevention of harm to our resources, exercising caution in favor of promoting water security, and approaching remedy considerations from the point of view that the polluter and the user must pay. These can only be of benefit to all citizens in our country. They are universal considerations. Courts are in a position to transform the lives of people whose trust in them is engendered by their independence, subject, of course, to the constitutions of specific countries and the laws of the countries. Courts' orders bind and all persons state to which they apply. Ancillary remedies such as structural or supervision interdicts can be used to reinforce court orders, together with relevant sanctions and penalties where those are provided. But of most of most importance for today is that the principles guide us and afford us space to think creatively, further to the pronouncements that already exist and remedies that are already in existence. By and large, organs of state do not interfere with the functioning of the courts, and the orders that we issue are a crucial social construct in this way. The declaration empowers us as judges by setting out crisply the principles that we can infuse in our decision-making process to realize the goal of water security. This event provides us with opportunity to revisit these principles and reaffirm our commitment to discharging our duties for promotion of water security and to add weight to the project of averting the impending water crises that could strike at the heart of our respective communities. Thank you very much, colleagues, for listening to me, and especially to Justice Antonio Benjamin for your visionary leadership on these issues. I thank you. And without further ado, I introduce our next presenter, Justice Alfredo Gutierrez. Over to you, Justice Gutierrez.
Hello, it's a pleasure to be here with you today. I also want to thank Antonio Benjamin for the invitation and for, as usual, bringing us all together on such an important topic as the one we are discussing today. Let me be very brief. I just want to mention some recent Mexican cases where we have cited the Brasília Declaration. Many of you may not know, but since 2012, the Mexican Constitution was amended and it established under Article 4 the human right to water. This allowed water issues to become justiciable in federal courts. And the courts have been very active, the Supreme Court especially. And it has cited the Brasília Declaration in 3 very recent cases. The Brasília Declaration is considered soft law in Mexico, but it has been cited and the principles have been used in several decisions. Principles that I know have been used in several Supreme Court cases are the water as a public interest, the ecological function of property, in dubio pro agua, the preventive, the precautionary principles, and user pay principles, and the internalization of environmental costs and externalities. Now, getting down to the cases, the first case was a federal state issue where the federal government had issued a decree for a natural protected area in the Yucatan Peninsula called Yumbalam-Holbox. Basically, what the federal government did was establish certain regulations that prohibited altering hydraulic flows and established some restrictions on water residues. The local government challenged the federal government, arguing there was an encroachment on its ability to establish zoning laws within the naturally protected area. The case worked its way up to the court, and the court decided in favor of the federal government, and it basically cited the Brasília Declaration, the principle of water as a public good. It also cited in dubio pro agua and the precautionary principle. to reach its decision in favor of the federal government, allowing the federal government to regulate water flow issues in this protected area. The second case, which I think was a very interesting case, it was a tax case. An individual was not paying his right to use water in excess of a certain amount, and the government restricted his access to water for lack of payment. He challenged the case in court under the right to use water, and the case again worked its way up to the Supreme Court, and the Supreme Court ruled in favor of the federal government. And it cited specifically the principle of the user payer principle, and it limited the individual's use of water to 50 liters per day until the tax had been paid in full. And now the third case, and the final case I want to mention, it had to do with the use of an aquifer in the northern part of the country. Many of you may not know, but the northern part of the country is almost all desert. So water is a very scarce and important resource. The federal government had been issuing concessions, permits, to allow individuals to have access to the aquifer and the water which it produced. Local residents challenged the federal government, arguing that the federal government had no rational basis for the permits it was issuing, and the permits were not issued on sustainability grounds. The Supreme Court ruled in favor of the individuals, but what is really important about this case is that it really expanded standing for these type of cases. These were people that were residents of the zone, but they had no permits. They regularly would have no standing to challenge, but because of water, because it was a water issue, the Mexican government, the Supreme Court ruled in favor of them, opening or expanding what would be traditionally understood as standing. I think those are three very important cases that the Supreme Court has recently ruled on, and they have really opened up litigation in Mexico on water issues. And all three cases were decided on principles that were established in the Declaration of Brasília. Thank you very much.
Thank you, Justice Gutierrez, for that overview, and in particular for showing us that the declarations and the principles espoused therein are already taking hold in the decisions that are made in our courts. Our next speaker is Justice Reyna.
Merci beaucoup. D'abord, je voudrais remercier le juge Benjamin de m'avoir invité à participer à ce panel. Je suis très heureux de me retrouver avec vous tous et d'avoir l'occasion de partager avec vous un certain nombre de réflexions sur cette question qui, un certain nombre d'entre vous l'ont dit, est particulièrement importante compte tenu de ce qu'il peut y avoir une vie sans amour, comme le disait tout à l'heure l'un des précédents intervenants, mais il ne peut pas y avoir une vie sans eau. Et donc, moi, ce que je voudrais dire, c'est deux séries de choses. D'abord, peut-être des considérations liminaires qui sont un peu moins optimistes que certains des intervenants précédents, pour dire que en France, en tout cas devant le juge administratif français, la déclaration de Brasilia, malheureusement, n'est pas encore, à mon avis, assez connue et n'est pas encore assez souvent utilisée par les requérants et donc derrière les requérants par les juges. Vous savez que la France est un pays
moniste dans lequel le droit international donc est directement applicable et peut être directement invocable devant les tribunaux, mais la déclaration de Brasilia, peut-être aussi parce qu'elle n'est pas encore du droit dur, elle n'est pas encore, à mon avis, assez souvent invoquée devant les tribunaux administratifs et notamment devant les tribunaux administratifs et le Conseil d'État français. Je crois que, comme c'est une déclaration très importante, ça a été dit à plusieurs reprises, très complète, très riche, je crois qu'elle gagnerait à être davantage connue, davantage exploitée par les associations de défense de la nature, les requérants, et donc à être utilisée devant les juges. Alors, ceci étant, je voudrais citer un certain nombre de décisions, je voudrais en citer 4. 3 qui ont été rendues par le Conseil d'État et une par un tribunal administratif, le tribunal administratif de Montpellier, pour illustrer quand même la convergence qui existe sur un certain nombre de questions entre la déclaration de Brasilia et le contenu qui est le sien et un certain nombre de décisions qui ont été rendues par le Conseil d'État et par les juges administratifs français, parce que le Conseil d'État et les juges administratifs français ont un certain nombre, enfin ont l'habitude de traiter de questions relatives à l'eau en particulier et à la protection de l'environnement de manière générale. Alors, je voudrais citer 4 décisions. La première, enfin les 2 premières étant de nature un peu générale. La première, c'est la décision par laquelle le Conseil d'État a reconnu comme un principe qui s'impose au pouvoir réglementaire, c'est-à-dire qui s'impose aux décrets, aux arrêtés, aux actes du gouvernement et aux actes des administrations, le principe de non-régression de la protection de l'environnement. C'est un principe qui, je crois, est un principe important. Et le Conseil d'État, par une décision de 2017, donc, qui précédait en quelque sorte la déclaration de Brasilia, le Conseil d'État a dit que le principe de non-régression de la protection de l'environnement s'impose au pouvoir réglementaire et il en a tiré des conséquences en annulant un certain nombre de décrets, un certain nombre d'arrêtés pour lesquels il estimait qu'ils portaient atteinte au principe de non-régression de la protection de l'environnement. La deuxième décision que je voulais citer, c'est une décision qui a été rendue tout récemment par le Conseil d'État, par la section du contentieux du Conseil d'État. C'est une décision de septembre 2022 par laquelle le Conseil d'État a jugé que le droit de vivre dans un environnement équilibré et respectueux de la santé, ce droit est une liberté fondamentale au sens que le Conseil d'État donne à ce terme. Et c'est une décision qui est importante dans la mesure où elle permet d'invoquer le droit à la protection de l'environnement devant le juge des référés, c'est-à-dire d'obtenir des mesures de protection en urgence. Et évidemment, c'est quelque chose d'important dans la mesure où les atteintes qui sont portées à l'environnement peuvent être irréparables et donc il est important que le juge des référés, qui peut prendre des mesures de manière urgente, puisse intervenir de manière extrêmement rapide pour obtenir, pour exiger des administrations et des pouvoirs publics en général qu'ils prennent des mesures qui soient respectueuses de l'environnement et respectueuses du droit à vivre dans un environnement équilibré et respectueux du droit à la santé. La troisième décision que je voudrais citer, c'est une décision par laquelle le Conseil d'État, à l'occasion d'un contentieux qui portait sur la construction d'une route, a apporté un élément modérateur par rapport à un principe qui était traditionnellement fort dans le droit administratif français, qui est le principe qu'on appelle le principe d'indépendance de la législation, c'est-à-dire que lorsqu'on a une décision qui concerne la construction d'une route, on confronte cette décision relative à une route au droit applicable aux travaux publics, au droit applicable en matière de construction de routes, etc. Et on ne le confronte pas à d'autres branches de législation, et notamment à la législation de protection de l'eau. Et par une décision de 2021, le Conseil d'État a jugé que une construction d'une route peut avoir un impact sur la ressource en eau. Et donc, cette décision relative à la construction d'une route doit être considérée comme une décision relative à l'eau lorsque la construction de cette route est susceptible d'avoir un impact sur la ressource en eau, que ce soit parce qu'elle est de nature à porter atteinte à la ressource en eau directement, ou parce qu'elle est susceptible de porter atteinte à la ressource en eau dans la mesure où la construction d'une route a des effets sur les risques en matière d'inondation. Ça a été rappelé par le collègue du Pakistan tout à l'heure. Et donc, je crois que cette décision est importante parce qu'elle dit il y a des décisions administratives qui peuvent être en principe éloignées de l'impact sur la ressource en eau, mais qu'il faut quand même confronter à la logique de la protection de la ressource en eau. Le quatrième exemple que je voudrais citer, c'est une décision qui a été rendue tout récemment, cette fois pas par le Conseil d'État, mais par le tribunal administratif de Montpellier. C'est une décision qui a été très commentée en France, parce que c'est une décision par laquelle le tribunal administratif a été amené à se prononcer sur l'utilisation de la ressource en eau et confronter cette utilisation avec d'un côté l'agriculture et de l'autre côté la protection de la nature, et notamment la protection de la vie aquatique, c'est-à-dire les poissons. Et le tribunal administratif a été amené à contredire ce qui avait été décidé par le préfet en jugeant que si on permettait un usage trop important de la ressource en eau à des fins agricoles, eh bien, on mettait en danger la vie de la ressource aquacole et notamment la possibilité pour les poissons d'avoir dans les cours d'eau suffisamment d'eau pour maintenir la vie aquacole et donc la vie des poissons. Et donc, le tribunal administratif est venu contredire la décision qu'avait prise le préfet pour exiger que l'usage fait par l'agriculture de la ressource en eau ne soit pas trop importante au point que ça mettrait en danger la vie des poissons. Donc voilà un certain nombre de décisions qui ont été rendues par les juges administratifs français et qui vont, je crois, dans le sens du contenu de la déclaration de Brasilia, même si la déclaration de Brasilia elle-même, comme je le disais en introduction, n'est pas encore, à mon avis, assez connue des requérants français et des juges administratifs français. Merci beaucoup à tous.
Thank you, Justice Reno. Yeah, that reminds me that our water tribunal also may not be aware of the declaration, and I promise to take to their attention. Thank you for those remarks. We are a bit out of time already. There's a change in the program in that Justice Joe Williams has been replaced by Justice Christina Wata, also from the High Court of New Zealand. Without further ado, Justice Wata, you may.
Kia ora, everybody. Yes, it's Christian, actually, Christian Fata, Justice Christian Fata.
Sorry.
Not at all, not at all. I'd just like to start by saying what a privilege it is to participate, but also to listen to the various ways across various jurisdictions that we are dealing with the issue of water rights and water management. If I have to get up at 1 o'clock in the morning to hear anything, it's good to hear this. Just a little bit of background briefly. I'm a High Court judge. I'm also a law commissioner. And the reason that perhaps is a little bit relevant in terms of the topic I'm going to talk about is at the moment the Commission is embarking on a project concerning Indigenous law and Indigenous rights. And it's with great interest to look at Principle 3 of the Declaration and the affirmation there of Indigenous rights and the affirmation of Indigenous knowledge. So as you've probably anticipated, that's what I'm going to speak about today. I'm going to speak about how New Zealand law is giving effect, at least, to that principle. And I have to, I regret to say, our case law is slow. We haven't yet expressly incorporated or dealt with the principles. But I hope to illustrate that, at least in one respect, and that is in respect of Indigenous rights, we are building a corpus of law which gives effect to that principle. Now, very briefly, for those who are not familiar with New Zealand, the Indigenous people of New Zealand are Māori, and our Indigenous law is therefore Māori law. I'm going to start by saying that in recent years, our law has started earnestly to incorporate Māori law into it, our state law, and the Supreme Court has recently affirmed that Māori law is the first law of New Zealand, and that by a majority, at least, our Supreme Court has said that Māori law is an independent source of law. Now, one of the presenters before, Justice Syed Mansour Ali Shah, talked about the importance of making the environment the center of things rather than human interests. If I was to say one thing about Māori law, is that that's exactly what it does. And in fact, Māori law, like much of Indigenous law, we conceive of the environment, the mountains, lakes, rivers, the sea, and of course water, generally as elders of our particular tribes. We have a direct relationship with the environment in our law. And this, of course, is a powerful normative starting point for our engagement with the environment, because it demands that we treat the environment as we would one of our own and one of our members of our family. Within Māori law, therefore, we have particular norms which seek to give effect to that very basic principle. And two of those norms are notions of mana and tapu. Now, I won't go on at length about it, given the length of time I have to speak, but really it speaks to the inherent worth and the status of lakes, rivers, water generally to Māori. And so in Māori law, the environment is not simply a resource to be used or even a resource to be managed. In Māori law, what we do is we manage our relationship with the environment as if it was and exists as a person. Now, the second point I want to make is that we have conceptualized the environment in this way for at least 30 years in New Zealand law, by incorporating notions of guardianship and responsibility we have to the environment. I have to say it's been a slow burn in terms of realization of that particular conceptualization, but we certainly have legislative recognition now of concepts of what are called kaitiakitanga, or guardianship, and the role of governments and of iwi and hapu, their tribes, to provide guardianship of resources. Now, the third point I want to make in relation to Māori law is that we've started to incorporate it directly into statute, which is particularly relevant in this context in terms of the Principle 3, in that we have statutes now that identify at least some rivers as if they are legal persons. One such act is called the Te Awa Tupua Whanganui River Claims Settlement Act of 2017. The Whanganui River is located in the middle of our North Island. We're a country of two islands, and Whanganui is located in the middle of the North Island, and that it goes from the mountains in the middle of the island and through to the west coast. Now, what the statute does is it effectively, as I say, it recognises this river as a legal person with the right to sue. Now, we haven't quite seen how that manifests itself in terms of case law, but it's a really important articulation and respect for the Indigenous view of water, of rivers and lakes. This particular statute incorporates that recognition in a number of ways. not only as a legal person, but all of the values that wrap around that river have legal content and legal effect. Now, the fourth point I wish to talk about relates to future direction. The law of New Zealand is undergoing a process of transition from law largely dominated by state law, but deeply rooted in the common law traditions, largely inherited from England, to a law that recognises almost inherently Māori legal values and norms. And this is particularly important in relation to the environment for the reasons that I've just mentioned in terms of Māori law's inherent recognition of the environment as a living entity. So we currently have before Parliament a statute which has as one of its primary purposes to recognise and uphold a concept, te oranga or te taiao, which is the well-being of the environment. Now, this goal is, if this legislation is passed, provides, among other things, the promotion of system outcomes, which are directly about protecting the mana, that is the inherent authority and status of lakes and rivers, and the recognition expressly of the laws and norms of the tribes that have a relationship to those rivers. It's further significant because all decision makers under the statute must recognise and provide for that mana of not only of the river or the lakes or other water resources, but also of the people that are connected to them. And the bill also provides for special mechanisms that elevate the status of rivers, designated rivers in the country. Knowing that I had such a short time, I'm going to end it there. But what I will conclude by saying is that the jurisprudence of our environmental court has evolved over time from a place where matters of importance to Māori have been consistently framed in non-Māori terms, so non-Indigenous terms, to a point where Māori conceptions of the environment are recognised as having, as worthwhile recognising by the law. And I think that's particularly important as an indicator that Indigenous worldviews perhaps offer solutions in a time of such climate crisis. So short but sweet, I hope.
Very sweet, Justice Water. I can assure you that in this continent of Africa, we don't regard you as slow at all. We've been looking quite a bit up to you and your development of Indigenous laws, and we will be looking out as to how you will be giving interpretation to the recognition of the Frangani rivers and the other developments that you referred to. Thanks again very much. Colleagues, the last presenter is Justice Lindblom, Lord Justice Lindblom.
Thank you very much, Nambitha. As the last presenter, I am acutely conscious that time, like water, is a valuable resource. So I will keep my remarks succinct, I hope. In all the jurisdictions convened here, the principles of water justice referred to in the Brasília Declaration operate within the constitutional arrangements of each country, including, of course, the rule of law and the independence of the judiciary, to justly to regulate the use and quality of water as a vital natural resource. What I would like to do briefly is to explain how the law in the United Kingdom attains those objectives, and to consider the extent to which our law reflects the principles stated in the Declaration. Let me start with the first two principles, which concern the proper stewardship of water. They look to the state and those with rights over water, including water companies, to take active steps to make the supply of water sustainable and generally to avoid its pollution. Now, the law in the United Kingdom achieves this largely through statutory regulation. Thus, for example, the Water Industry Act of 1991 imposes duties on water and sewerage companies, including, for instance, a duty to prevent the deterioration of water quality in the process of supplying it, and a duty to promote the efficient use of water. Other legislation, the Water Resources Act of 1991, introduced a classification scheme for assessing water quality and gave the executive the power to set quality objectives for environmental agencies. More recently, the Water Act of 2014 introduced a resilience objective, which imposes a duty on the government to secure the long-term resilience of water and sewerage supply systems as regards environmental pressures, population growth, and changes in consumer behavior. And there is, of course, in our law, a further layer of protection under European Union legislation, including in particular the Water Framework Directive of 2017, which imposes duties on the government to prevent the deterioration of quality of river basins and to achieve targeted levels of water quality. That then is the legislative framework within which we can view the principles that go further under the declaration and amplify the duty to protect water resources. Let me then turn particularly here to principles 4 and 5, which articulate the principles of prevention and precaution. Here again, legislation provides the substance. The Environment Act of 2021 gives effect to those principles. Section 17 requires the government to produce a policy statement on environmental principles, defined as a statement explaining how the environmental principles should be interpreted and proportionately applied by ministers when making policy. And those principles include the preventative principle and the precautionary principle, which are fundamentals in our law. They are effective, albeit flexible, legal duties, and they have real teeth. A minister's failure to have regard to the relevant principles in the way the duty requires when formulating policy may render such policy legally defective. Standing back a little further, our system of judicial review, which is a relatively highly developed jurisprudence in the United Kingdom, effectively ensures that decision makers comprehend the risk of environmental harm where such risks are legally relevant considerations. Sometimes, of course, the precautionary principle is directly in play. And as a firm and long-established principle of European Union law, it was, for example, relevant to the court's assessment in a case concerning the legislative framework for environmental impact assessment. And that, all of that, of course, as a generality, applies with particularity to water resources and their management and control. Let me turn to principle 6, and here I must say the position is somewhat different from what I can say about the other principles. This has been the subject of some debate in the course of the morning. It effectively calls upon judges to decide cases of uncertainty, as it's put, in a way that best preserves the water resources and the environment generally where water resources are concerned. This is the in dubio aqua principle. It would, I have to say, not be right to describe this as a current and specific principle of our approach in the United Kingdom to legal disputes or to statutory construction. Thus, for example, in a case in the Court of Appeal, where the court had to determine the statutory definition of trade effluent, and whether that in particular included the mixture that results from discharged wastewater, later compounded with stormwater. The notion that the court would be obliged to prefer an interpretation of the relevant statutory provisions because such an interpretation might lead to a more beneficial outcome for water resources or more generally for the environment, indeed provided no part of its reasoning. The analysis there in a conventional way focused instead on determining the objective intention of Parliament in formulating the provisions as they were, not to give preference to the interests of water resources. And that, I think, is a prevalent theme in our jurisprudence. Let me turn to principles 8 and 10, where I can say something perhaps a little different. We're concerned here with the environmental rule of law, a principle which is becoming firmly embedded in our jurisprudence. And in particular here, to ensure that the environmental regulation is accessible to the public, and that the courts themselves are accessible to the public, and the law is effectively enforceable by individuals as well as by corporations and NGOs. The accessibility of legal process to the public is, of course, primarily a question of standing and costs. And to challenge an administrative decision alleged to be unlawful, including decisions in the sphere of environmental regulation, there is a very wide requirement for standing under Section 31 of the Senior Courts Act 1981, namely that the applicant has merely a sufficient interest in the claim. And this is a broad and liberal test, and it has not in practice proved difficult for individuals or indeed NGOs to meet it. And that would apply equally in the sphere of water resources as it does more generally to other environmental considerations. And then let me turn to costs, because here again I think it's important to look at the nuts and bolts of how the system operates. We have a rule in our procedural rules, Rule 45, which sets limits on the potential costs liability of claimants in what are called Aarhus Convention claims. And generally the limit is £5,000 for an individual claimant, £10,000 otherwise. And these relatively low limits make recourse to judicial review reasonably accessible to the public. They are both realistic and predictable, both of which are important, of course, and that they materially reduce the risk or perceived risk of bringing a claim for judicial review. Principle 9, if I can just come to that, calls for a holistic approach by the court to adjudication in proceedings relating to water and water resources, viewing the issues in an appropriately broad environmental context. And that is inherent in the court's approach in the United Kingdom, without, of course, distracting it from its primary focus on the particular issues in dispute in the case before it. I think that is important to acknowledge. Courts are limited in what they can do by the circumstances in which their adjudication is called for. And that has been the incremental approach in the common law jurisdictions for which I speak. Finally, then, let me say something about enforcement, because I think in all questions of the environmental rule of law, enforcement is really at the heart of our consideration. In the United Kingdom, I think it is fair to say that pollution control, including control over the pollution of water, has a reasonably good track record. For example, prosecutions for water pollution offences have a high rate of success, a very high rate of success. In exercising their discretion on sentencing in criminal cases, our judges have also taken into account the importance of discouraging activities that generate pollution. Thus, for example, in the Thames Water Utilities case, which I think is widely known, a case concerning the unlawful discharge of sewage into a brook, the court recognised that fines for pollution offences for large companies, and many of these companies are, of course, large and powerful companies, had to be sufficient to influence company behavior. I don't want to give too Panglossian a view of the way things are in the United Kingdom. That would not be my intention. But I think it is fair to say that in large measure, the principles enshrined in the Brasília Declaration are relevant, are reflected in relevant United Kingdom legislation and jurisprudence, and are being given effect to in the decisions of courts in our jurisdictions. There are, of course, 3 jurisdictions in the United Kingdom, for only one of which I formally can speak, according always, of course, in the best traditions of the common law, to the facts and circumstances of the individual case. Thank you very much.
Thank you very much, Keith, for that legal framework overview that reminds us of our commonalities and those aspects in our interpretative principles that still hold us back from giving expansive interpretation to some of the statutes that we interpret every day. Colleagues, we have reached the end of the session, and I shall therefore give the reins back to Denise. Thank you very much.
Let's global applause for our wonderful panel. Thank you, Justice Nambita Dambuza, for your wonderful remarks and for chairing that panel. We are a little behind. However, this conversation is so rich and important. We don't want to rush it. This is a moment in time that we must seize. But let me seize it by turning it right over to Justice Andromika Karantasanas. Apologies. So you can chair the next panel with your colleagues. Please go ahead.
Thank you. I am delighted to participate in this important conference and to chair the closing keynote. It's a real privilege to be able to learn from such an impressive range of judges, scholars, and diplomats from across the globe, all committed to water justice. As I reflected on the themes of this event, I realized that although Canadian courts have not expressly centered their decision-making on water justice as such, many decisions nonetheless reflect the principles and goals of the Brasília Declaration. For example, as we've heard, the Declaration expressly recognizes that climate change has accelerated the impending water crisis, and effective management of water resources is critical to climate change adaptation. In 2020, the Supreme Court of Canada heard a case concerning the constitutionality of Canada's legislation, setting national standards for greenhouse gas emission pricing. And the court stated, climate change is real. It poses a grave threat to humanity's future. It generates particularly devastating risks to Canada, including to water resources and ecosystems. The court recognized that climate change poses disproportionately high risks to the Arctic, as well as to the Indigenous peoples of Canada, threatening their ability to sustain themselves and maintain traditional ways of life. So these risks to water resources and ecosystems and the people that depend on them informed our court's recognition of climate change as a matter of national and global urgency. In the words penned by Chief Justice Wagner, the undisputed existence of a threat to the future of humanity cannot be ignored. So in this way, the decision reflects not only the Declaration's recognition of the climate crisis and water-related impacts, but also its first principle, that water is a public interest good, that the state should exercise stewardship and protect for the benefit of current and future generations. So indeed, much like the UK and some of the other countries, although the Declaration has not been referred to in Canadian law. Many of its principles are reflected in our laws and jurisprudence. In line with Principle 5, the Supreme Court has relied on the precautionary principle in interpreting environmental protection legislation. Almost all Canadian environmental legislation includes the polluter pays principle, recognized in Principle 7, and judges routinely apply that principle under environmental legislation, thus reflecting Principle 8, that good water laws and their effective implementation and enforcement are essential. Canadian precedent also reflects Principle 3, which recognizes Indigenous peoples' customary rights to traditional water resources and related ecosystems. Our seminal decision, 1990 decision in Sparrow, confirmed the significance of Indigenous worldviews on water issues and recognized a customary right to fish. Our jurisprudence affirms that the government must meaningfully consult with Indigenous peoples where its actions may infringe on water-related rights. And in a decision I wrote in Natchanyuk, the court recognized the significance of the Peel watershed region, one of the largest wilderness watersheds in North America, and its importance to Indigenous nations in the Yukon. With that brief discussion of how Canadian laws and jurisprudence have reflect many of the principles, I will turn to introducing our two key distinguished speakers on this closing keynote. Chief Justice Norma Pina of the Supreme Court of Mexico and Ambassador André Correa do Logo of Brazil's Ministry of Foreign Affairs. And our first speaker is Chief Justice Pina, who has been a Justice of Mexico Supreme Court since 2015, and she became the court's first female president in January. Congratulations. And prior to becoming a judge in 1998, she served as a clerk and legal opinion drafter in Mexico's judicial system for a number of years, and I believe started her career as a professor of primary education pedagogy. I understand her remarks are recorded, so I'll turn it over to those who can show us those remarks.
Saludo con enorme gusto desde México a mis colegas de las Cortes Supremas de Justicia, los tribunales constitucionales y los órganos de vigilancia de las judicaturas federales, así como a todas las personas reunidas hoy en atención a esta urgente convocatoria que una vez más nos hace el incansable ministro Antonio Germán Benjamín, presidente del Instituto Judicial Mundial del Ambiente, junto con las importantes instituciones organizadoras. Nos reúne un tema absolutamente prioritario y cuya atención no puede esperar más: la justicia hídrica. Quienes participamos en este evento lo hacemos con un sentimiento común: preocupación, porque sabemos que estamos demasiado lejos de cumplir las metas que nos hemos propuesto para detener y revertir la crisis hídrica mundial. Metas que son inseparables de los esfuerzos todavía muy insuficientes para enfrentar la emergencia planetaria que están causando el cambio climático, la contaminación y la pérdida acelerada de la diversidad biológica, así como sus servicios ambientales en todas partes del mundo. Las grandes desigualdades persistentes que impiden a millones de personas tener acceso al agua segura, asequible y suficiente, así como el saneamiento, nos confronta con deudas inaplazables en los sistemas de justicia para garantizar a las personas del presente y del futuro sus derechos más fundamentales, incluyendo, claro está, el derecho a la vida y a vivirla en un medio ambiente sano, sin las indescriptibles amenazas que impone el cambio climático global. ¿Por qué no hemos logrado detener de una vez por todas la crisis hídrica global cuando todas las personas en este mundo vivimos la importancia esencial del agua para nuestra existencia? La Declaración Judicial de Brasilia sobre Justicia Hídrica que nos congrega es un punto de partida fundamental para detener la crisis hídrica global. Ahora, nuestro reto es que sus principios se materialicen, que en las decisiones de cada corte y tribunal en el mundo, juzgar con perspectiva de justicia hídrica se convierta en una función innata a nuestros procesos de adjudicación. Señoras y señores, debemos de hacer todo lo que esté en nuestras manos para que en cada decisión judicial, a partir de los principios de Brasilia, primero, hagamos valer el interés público implícito en el uso sustentable, la conservación y la restauración de los recursos hídricos por encima de intereses privados o de cualquier otro interés contrario al bien mayor de los derechos colectivos y de la naturaleza que dependen del agua segura y suficiente, con un enfoque de justicia intergeneracional. Segundo, reconozcamos la función ecológica que debe cumplir el uso de la propiedad cuando adjudiquemos casos en los que se requiere imponer modalidades al uso del suelo y otros recursos para defender la integridad de los ecosistemas hídricos y, cuando sea necesario, obligar a su restauración. Tercero, seamos inflexibles al exigir que en cada actividad donde puedan afectarse ecosistemas hídricos se lleven a cabo evaluaciones de impacto ambiental con la debida diligencia que demanda el principio de prevención. Cuarto, desarrollemos estándares de prueba estrictos para aplicar el principio precautorio en la adjudicación de controversias donde exista un riesgo para los ecosistemas hídricos y sus servicios ambientales. Se establezca en cada decisión y revisión judicial un rigor muy alto al estándar de la mejor información disponible para que la incertidumbre y la carga de la prueba nunca se argumenten en contra de la justicia hídrica y climática. Quinto, logremos que el principio indubio pro agua, un ejemplo del poder creador de la función judicial para el desarrollo progresista del derecho ambiental, informe las decisiones y actos de autoridad para que en cualquier disyuntiva siempre se resuelva a favor de la justicia hídrica y la protección de los ecosistemas hídricos. Sexto, establezcamos en nuestras decisiones efectos que logren en la práctica la internalización de los costos de la contaminación del agua como un acto de justicia colectiva. Que nuestras sentencias constituyan una fuerza disuasoria capaz de evitar daños ambientales futuros a través de un enfoque de responsabilidad ambiental objetiva estricta. Séptimo, contribuyamos a la protección social de quienes no pueden pagar los costos por el uso doméstico del agua y logren acceder a la provisión adecuada de servicios de agua potable y saneamiento. Octavo, mandemos un mensaje claro en cada decisión judicial para que las comunidades indígenas y tribales, así como los defensores ambientales, encuentren en los derechos de información, participación pública y acceso efectivo a la justicia hídrica las herramientas necesarias para proteger sus territorios, medios de vida y derechos fundamentales. A una vida digna en armonía con la naturaleza. Es necesario decirlo claramente. La injusticia hídrica, incluyendo la destrucción de los ecosistemas y sus servicios ambientales, lleva implícita una derrota demoledora en la búsqueda por lograr sociedades incluyentes, justas y sustentables. Pero la declaración que hoy nos convoca nos demuestra que somos más quienes desde la judicatura impediremos esa derrota, quienes no aceptaremos la desigualdad en el acceso al agua y al saneamiento como un estado inevitable de las cosas, quienes nunca renunciaremos a nuestra responsabilidad de conservar, proteger y restaurar la naturaleza y sus servicios ambientales para las generaciones de hoy y para las del mañana. Quienes de frente reconocemos y aceptamos nuestra responsabilidad esencial para lograr una verdadera justicia ambiental, hídrica y climática. Muchas gracias.
Yes, thank you, Chief Justice Pena, for that passionate call to action with 10 principles. Our next speaker is Ambassador Andre Correa do Lago, a diplomat for nearly 40 years, and he recently became Secretary of Climate, Environment, and Energy at the Ministry of Foreign Affairs of Brazil. He has served as Brazil's ambassador to India, to Japan, and notably, he served as Brazil's chief negotiator for climate change and sustainable development, including at the Rio +20 UN Conference on Sustainable Development. Ambassador, over to you.
Thank you. Thank you very much. Let me start by congratulating all the participants for their interventions. I learned so much today, and I thank all how advanced and how interesting this subject is at the moment. I thank particularly Justice Herman Benjamin, who is a dear friend for many years and who invited me to be in this remarkable event. Justice Benjamin is very respected in my country and is an exceptional actor in the sustainability debate in Brazil. As most of you know, water is a central issue in Brazil's foreign policy in many areas. Not only Brazil holds 12% of the world's freshwater resources, but also in its impact on hydropower, which is the main source of electricity in my country, and the importance of rivers for transportation, for food, and are a basis of the way of life of numerous communities. The social, environmental, and economic importance of water in Brazil cannot be overstated. Its use and management, therefore, need to be undertaken in the most sustainable way possible. It is a responsibility, and it is a responsibility Brazil is ready to assume. As was made clear throughout today's interventions, courts play more and more a crucial role in the implementation of SDG 6 and by extension of all related goals and targets of the 2030 Agenda for Sustainable Development. And naturally, in the context of the fight against climate change, this is absolutely a central debate. The Brasília Declaration is definitely a pioneering document, and I am more convinced of it after this session. It bears witness to the activities and the commitment by judges around the world to make sustainable development a reality. The 2030 Agenda remains central to overcoming the many challenges the world faces today, starting with the eradication of poverty. The COVID-19 pandemic and the growing geopolitical tensions have imposed challenges to the implementation of the 2030 Agenda. So we have to redouble our efforts. By enforcing environmental protection legislation, be it under the form of multilateral environmental agreements or domestic legislation, and by holding a comprehensive perspective that also considers social and economic objectives in our societies, judges are powerful allies as our countries pursue the implementation of the SDGs. This year, the UN Water Conference, the high-level political forum in July, and the SDG Summit in September will contribute to the political momentum necessary to these efforts. Today's event, one of the first in that context, certainly contributes to a much-needed reflection on where we are and how we should proceed to achieve the goals and targets relative to water. I therefore thank you all very much for this opportunity to participate in this event and congratulate all the organizers for this initiative. Thank you very much.
Well, thank you, Ambassador, for framing this within the broader environmental challenges ahead. I want to thank all of our very impressive speakers, both on this closing keynote and on the previous panels, for the incredible insight and passion for water justice, and to thank the organizing partners for making this important event a reality, and in particular to Justice Benjamin for his inspiring leadership. You know, the Brasília Declaration highlights the immense significance of water-related disputes for our global future. And we've heard today how its principles resonate and provide practical guidance to judges within the limits of their own jurisdiction to help ensure that the arc of the legal universe bends towards water justice. And events such as this help to make real the promise of the Declaration. On that note, I look forward to hearing from our next speaker, Professor Denise Antolini, regarding the outcomes for this event.
Thank you very much, Justice Karen Katsanis. I hope I pronounced it appropriately. Karakatsanis. We're all learning. And just again, a global round of applause for this amazing panel that we just heard. So thank you so much. I'm going to reduce my outcome remarks to 2 minutes. Let's see if I can do it. And with the blessing of my colleague, Professor Nicholas Breiner, we will continue to elaborate later. But I had 5 outcomes that I wanted to share that I've heard. One is the tremendous power of capacity building that this declaration has sparked. So the conversation, it's been referred to as a conversation, education, and I think Justice Demars said, you feel connected, and to connect to judges who often have very isolated roles around the world is a powerful tool. Second, we have learned so much about how law progresses. You know, soft law is incredibly valuable tool, and we've seen the evolution of the law throughout all of the speakers. where it's a framing tool or principles or application that's explicit or implicit. This is a shining example of how law moves around the world and creates this global, powerful global conversation. Third, we've seen the profound connection between water justice and human rights, the rights of nature, climate justice, standing, access to the courts, indigenous knowledge, and the rights broadly that are expanding across the globe. So the profound connection of water to all aspects of law and life. Fourth, I think we've had some wonderful presentations about the need to have a biocentric perspective on water justice from Justice Wata and then from my good friend Rhiannon. Indigenous law provides us a guiding example, as Justice Nambita Dambuza said. We look to New Zealand and other jurisdictions for their leadership to lead us forward in how water law in particular provides a relationship, a holistic context for what can sometimes be dry law. It is not dry at all when water is part of your family, part of your being. Last, going forward, there's some big challenges ahead for this group. Judges, I think Scott said, judges are explainers, they are champions. There is an obligation with this declaration to continue work. Again, even if the application is not explicit, it can be implicit and very powerful. As Justice Nambita Dambuza said, the public has great trust in the judiciary, and so you are entrusted to carry the conversation forward. And lastly, let me conclude with something that Arnold Karlhuber said, which is the importance of this declaration on water, but there are possibly other declarations that could come within the environmental rule of law framework. So the work is not over, but this is an incredible template for that future work. So with that, I will turn it over to Ayman, my good colleague Ayman Sharkawi, who's the Deputy Chair of the World Commission on Environmental Law and Director at the Hassan Second International Center for Environmental Training, to start us off with the closing remarks. Take it away, Ayman.
Thank you very much, Denise. Greetings, everyone. Such a delight and a pleasure to be part of this important event. Firstly, I wanted to renew Christina's thanks earlier to our co-organizers, the Global Judicial Institute on the Environment, the Ministry of Foreign Affairs of Brazil, the International Association of Judges, UNEP, of course, as well as the International Council of Environmental Law. In the previous session, we talked about where we currently are in terms of making that diagnosis. And this particular event, of course, takes place in the context of the UN World Water Week, which itself takes place in the context of the Water Action Decade that, just like the Brasília Declaration, started in 2018. Since then, where do we stand? Well, first, nowadays, 1/4 of the population use unsafe drinking water sources. Governments must work an average 4 times faster to meet the SDG 6 on time. The UN World Water Conference that is starting today before the formal high-level opening earlier next week is the second of said event. The first of them having taken place in the 70s. In the 70s, my country, Morocco, where I live, had a water availability that is 3 times per capita what it is nowadays. Once again, reiterating the urgency and the importance of acting now, acting at pace and acting together. And in the interest of time, we'll just end with a quote from Lao Tzu, who said, quote, "Nothing is softer or more flexible than water, yet nothing can resist it," end of quote. And I think in terms of being irresistible, the power of the partnerships that is leveraged, that is represented in this event today is, in my belief, irresistible when it comes to the transformative power of environmental law to address global environmental challenges. So thank you very much. Thank you to all the co-organizers, all the speakers, all the participants, the translators as well, that have been doing a tremendously effective and professional job. Thank you. And finally, of course, I wanted to pay a special tribute, of course, to the leadership of Justice Antonio Benjamin, to the commitment and engagement of Denise, as well as Nicholas Briner. Apologies, I'm not sure who's ringing the bell. And finally, to the important work of our water and wetland specialist group led by Stefano and Michael. Thank you very much.
Thank you, Ayman, for those beautiful remarks and for expressing our gratitude, particularly to the interpretation team who is madly trying to keep up with you. With that, let me introduce Montserrat Abad Costellos, a professor of public international law at the Universidad Carlos III de Madrid. She is the Vice Chancellor of the International Council of Environmental Law. Montse, please proceed.
Muchas gracias. Buenos días, buenas tardes, buenas noches, señoras y señores. Es para mí un privilegio y un gran honor participar en la clausura de este evento y haberlo compartido junto a autoridades, magistrados de tribunales supremos de todo el mundo y otros distinguidos juristas sobre la Declaración de Brasilia en relación con la justicia hídrica. Esta declaración, como se ha evidenciado hoy de nuevo, es una valiosísima aportación jurídica para la implementación del Objetivo de Desarrollo Sostenible 6 y por consiguiente también de otros objetivos interdependientes y asimismo transversales para el futuro de la humanidad y del planeta. La Declaración de Brasilia se asienta sobre una profunda perspectiva de protección medioambiental, de derechos humanos y de equidad intergeneracional. En la visión publicada en la web de las Naciones Unidas sobre la Conferencia del Agua 2023 se recuerda más allá del valor esencial del agua para la existencia, que está indisolublemente ligada a los tres pilares del desarrollo sostenible. Y creo que debe enfatizarse también su vinculación con el cuarto pilar, el de la paz, puesto que es algo que viene cristalizando en la teoría, si bien a menudo todavía de manera implícita. Pero la relación con la paz tiene cada vez más fuerza, sobre todo desde la adopción de la Agenda 2030, del desarrollo del concepto del Estado de Derecho ambiental y de los principios de democracia ambiental. La escasez del agua y su gobernanza o gestión inadecuadas pueden ocasionar conflictos, incluso armados, tanto entre estados como en el interior de los estados. En consecuencia, el papel de los jueces potencial y real no puede ser más importante. Los jueces, en el ejercicio de su función, no solo resuelven disputas y conflictos en particular, sino que al hacerlo realizan otra serie de misiones judiciales que van desde la aplicación, la interpretación, la creación del derecho hasta la generación de seguridad jurídica y paz social. Por ello, la jueza costarricense Elizabeth Orio definió la justicia como una de las formas más altas de esperanza. Desde mi papel fundamentalmente académico y también como miembro de AISEL, veo con enorme interés y gratitud como jueces pioneros están ecologizando la justicia, haciéndola verde, resolviendo conflictos relativos a la naturaleza que precisan su intervención de manera holística, haciendo frente a las tres grandes crisis planetarias del clima, la biodiversidad y la contaminación, todas ellas ligadas al agua. Los jueces son decisivos para la creación de un orden público, jurídico, ecológico, para hacer efectivo el Estado de Derecho y social. Por eso se precisa que cunda el modelo y que haya más juezas y jueces planetarios, como ha escrito brillantemente el juez Benjamín. Se necesita que todos los operadores jurídicos relevantes y en particular los jueces tengan la convicción de que todo está íntimamente interligado en la naturaleza, que tengan los conocimientos de los principios y las herramientas jurídicas estratégicas que permitan proteger e impulsar esa interdependencia. Es, por tanto, una cuestión en gran medida de formación, pero también de actitud. Y el proceso de humanización y ecologización que ha ido experimentando el derecho, empezando a dejar atrás el paradigma antropocéntrico, debería también reflejarse en la agenda global para la acción que salga de la conferencia la semana que viene. Por ello, termino citando al juez Cansado Trindade, otro insigne juez brasileño, quien expresó hace 15 años en su libro Derecho Internacional para la Humanidad que son precisamente los ideales no cumplidos los que se revelan invencibles y que deben seguir impulsando moralmente a cada generación. Enhorabuena y muchísimas gracias a los organizadores, a los ponentes, a los asistentes y a los intérpretes.
Thank you for those beautiful remarks. And now, very appropriately closing this amazing event, Ministro Benjamin.
Well, many thanks. I'll be brief, and I have to be brief, to thank all of you. After the closing remarks by Montse and Eamon, inspiring, I don't have much to say to add to what they said. But I think it's important that we thank again our interpreters. Without them, we could be here, but we would not understand ourselves. And those that will be watching the recording or are watching us would not understand us. So many thanks to all of you. You don't know, but there is a UNEP team behind this video conference. And I would like to especially thank Alan Mezzo. Alan Mezzo is also the focal point at UNEP for the Secretariat of the Global Judicial Institute on the Environment, and Juliana Almeida. Juliana has been with us all the time. She's Portuguese, and of course I can speak Portuguese with her. And my final words is to my Brazilian diplomats to say that as a judge, a Brazilian judge, I'm very proud of all of you. From the very young diplomats, the ones that are just beginning their career, to those that are so seasoned as we have here, Ambassador André Correia do Lago, Ambassador João Genésio Almeida, who has been with us from the first minute of this event. Many thanks to all of you, to the speakers. Denise, in showing my gratitude to all the participants, I stress you, because it's 4 a.m. in Honolulu, and here is Denise with us, and in New Zealand, in Wellington, it's not that better. It's 2 a.m. and we had our colleague from the High Court of New Zealand. So this shows dedication, and dedication is absolutely crucial for our mission as diplomats, as judges, as scholars, and as citizens. So many thanks to all of you. And we meet soon. I don't know when and about what, but we'll meet soon. And this concludes our event. Many thanks.